May I please, my lord, on motion matter, my lord, it was filed on 24/4/2025. May I pray for listing, my lord, tomorrow or day after tomorrow, my lord?
When?
Motion matter, my lord.
When do you want?
Tomorrow or day after tomorrow. It was filed on, my lord, 24/4/25.
You take a date from him.
My lord.
Yes.
May I please, Lordship. Lordship, I'm paying for listing, my lord, just for correction of the order, Lordship. There is a typical mistake. Lordship, can it be tomorrow, Lordship?
Tomorrow?
Yes,
Correction.
Lordship.
For correction.
Only for correction. Oblige, Lordship.
May I please, your Lordship. In item number 19, Lordship, the respondent number 10 has filed an affidavit on 25. But this does not come on the record.
Item number 10,
Item number 19, Lordship.
sorry, 19.
The affidavit may kindly be called for.
May I please, your lordship, I beg to mention for listing, so matter may be come up 2nd of May, my lord. Dismissal from service, my lord.
Not second.
Take-
On
take a date
seventh,
from- Yeah.
seventh.
Time praying for a motion matter, Lordship, for listing on tomorrow or day after tomorrow, Lordship. We have some urgency, motion matter.
Monday.
Friday,
Friday already was given.
Friday, Lordship.
okay, we will try.
Yes, please, your lordship. My lord, this matter, my lord, listed last on, my lord, 16/5/2024, my lord. So we are supposed to, my lord, amend the writ petition, my lord. This is not yet listed, my lord. May I pray, my lord, day after tomorrow, my lord. Some urgency is there, my lord, relating to provincialization, my lord.
Monday, next month.
But can it be Friday, my lord? Because
Friday.
we are supposed to, my lord,
already fixed.
we are supposed to, my lord, amend the writ petition, my lord. That is, my lord, since it's not yet listed, my lord, that is the difficulty, my lord. Can it be on Friday, my lord?
No. Monday. Friday already a lot of cases fixed.
Yes. Yes.
Monday. Yes.
Please, your lordship, I beg to mention item number 20. Kindly pass over for the day.
On the appeal being made by Mr.
A. Talukdar.
A. Talukdar, learned counsel for the accused. The matter stands over for the day.
Highly object.
May I please, your lordship, I beg to mention for listing of a week matter for orders. Can it be on next week on any date?
Orders on 9th.
Take
Not
it.
published.
Maybe, Lordship, I beg to mention item number 4, with the consent of the other side, Lordship, kindly adjourn the matter for a week. My senior
Item
Mr.
number 4.
Lordship.
Or
Item number 4.
Lordship, kindly fix it in the next week, either on
Next
5th
week.
or 7th, my lord. 5th.
okay.
Commission matter.
That's agreed by learned advocates of both sides. This is the matter on
8th May. 8th.
Hearing date,
Hearing
7th.
date, 8th. 7th is Wednesday.
Okay.
8th May.
Much obliged.
May I please, your lordship, I beg to mention for listing, lordship. There is a full matter, lordship, relating to pension, lordship. Any date, lordship.
next week.
On
Take a date from him.
14th May.
Item number 2, my lord, can we pass what the matter? And it-
Item number 2.
yes. Item number. Yes. My instruction. So after
Any objection?
after a week, my.
Okay.
Date may be fixed.
Mr. Sharma, learned standing counsel for the respondents with consent from the other side, press for listing the matter after 1 week.
After 1 week.
And secondary education department.
Secondary education department. Okay. After 1 week,
Yes, after 1.
Your Lordship, date may be fixed. It's a part hard matter, man.
take a date.
On 21st May.
Obliged, my.
For motion item 1, sale application.
Agent Golden.
May I please, your lordship. Lordship, in this case, lordship, the petitioner is in custody since last 3 years, 1 month and 9 days, lordship. I preferred this present bail application, lordship, on 2 grounds, lordship. Prolonged incarceration and lordship ground of arrest were not furnished to the petitioners. It is from lordship, Shri Bhumi, lordship.
Yes, sir, Mr.
My lord, scan copy may be called.
Bhusha.
Scan copy may be called for.
3 persons are there.
Mr.
lordship.
Ahmed, learned counsel for the active, and Mr. Bhusha, learned additional for the state respondent. Yes. Petition under section 483 of the BNSS 2023 is referred for accused. Leighton Mia, who has been languishing in jail Azut in connection with Karimganj PS case number 190 of 2022 under section 22C 25 29 of the NDPS Act since 28/3/2022. for grant of
22,
bail.
Lordship.
Where is the petition and the documents placed on record? Let scan copy of the record along with the case be called for from the learned trial court. Along with a up-to-date status report fixing the matter. With
15th,
sorted.
9th, Lordship. For admission item
Highly
3.
obliged.
Item 3.
I need some time, Lordship, because so far as my information is concerned, this petitioner has got appointment in another college, Lordship. He may not be, Lordship,
Interested to pursue this.
Yes,
matter.
Lordship.
Heard Mr. Yudatta, learned counsel for the petitioner, and Mr. Padgiri for
Respondent number 6.
respondent number 6. Then
Higher education.
respondent number 6. None appears for the rest of the respondents. Mr. Dotto submits that he may be granted some time to obtain instruction from the petitioner as the petitioner got appointment in some other college.
Other,
And he may not be willing to pursue this matter. Accordingly, it is provided that recess unless the matter after 1 week,
2 weeks, Lordship.
2 weeks.
Obliged.
Item number 5.
None appears for the petitioner on call, list the matter after 1 week.
Item 6.
On the last occasion, I was directed to bring the service book, my lord. I have received the scan copy, my lord. Matter may take up in the next week, my lord.
Next week.
Fine.
Ms. Sutil, learned counsel for the elementary education department, press for listing the matter after 1 week.
My lordship, any date may be fixed.
26.
The pair having not been objected by learned counsel for the petitioner, stands allowed to list the matter on
26th.
for that.
19.
My lord.
Item 6.
7.
Item 7 and 8.
Like in this case, we have sent the affidavit for vetting, my lord. Matter may come next week, my lord, on Monday, my lord.
Next Monday. Next Monday.
Next Monday, my lord.
Okay. Ms. Sutil, learned standing counsel for the respondent authorities with consent from the other side, press for listing the matter next Monday. They are allowed, rest is list the matter on Monday.
Obliged, my lord.
My lord, one clear, my lord, this may be directed to place on record that affidavit, my lord.
Pardon?
The
My lord, we are
affidavit,
going to file affidavit.
that affidavit may be placed on record on next occasion, my lord. Otherwise, no, it can be, so that must be placed.
Okay, in the meantime, Ms. Sutil shall file her affidavit in opposition.
May I please, Lordship, item number 8 may be.
Okay,
Okay.
7 and 8.
7 and 8.
Next Monday.
Next one, obliged.
Item number 9.
My lord, regarding in charge headmaster, my lord, that pattern of decision passed by the honorable, including judgment passed by your lordship, is squarely covered. My lord, last time they have taken action. Second day. In fact, your lordship judgment, that is my lord Madhav Chandra Kolita's judgment, your lordship very elaborately discussed everything in that case, my lord. Because I am the senior most, my lord, I am the senior, my lord, depriving me, my lord, another person who is junior than me, he's been given in charge. But in, although that the order did not reflect anything, but it's presumed that, my lord, there is no permission for my B.Ed and other degrees, my lord. That is the, that
Permission?
permission for, my lord, my master degree and B.Ed. B.Ed, there is a permission, but for a master degree, there is no permission. That is their case. Probably, my lord, because in the order, it is not reflected, my lord.
Okay.
Your lordship kindly see, my lord, page 24, my lord, page 23, my lord. Page 23.
Yes.
Page 23, my lord, that is the, my lord, the time of retirement of earlier headmaster, my lord, in charge principal, my lord, forward the name of the, my lord, probable staff pattern, my lord, to the authority, my lord. That is page 23 is the forwarding letter and page 24 is the, my lord, list, my lord. Serial number 1 is already retired. Page 24, kindly see, my lord. 24 serial number 1 is already retired. I am serial number 2. Well, I am joining in 1995. Now, my lord, your lordship, kindly see serial number 4. Serial number 4, he is joining in 2014, my lord, very much junior than me, my lord. And he has been given, sir, that is, my lord, your lordship will find it page, my lord, 33. Page 33. Page 33. The smooth functioning of the school, so PGT board is hereby is allowed to look after us academic affair of the academic so. So that was the order, but the order does not reflect why I was deprived. So that's why probably in the last occasion they were asked, my lord, why he has not been given. But there is no affidavit. In fact, the private respondent, he received the notice but did not appear. Private respondent.
Mr. Siste, what is your instruction?
Lordship, I am extremely sorry, Lordship. There is no instruction in this case right now, Lordship. Lordship, may kindly give me 1 week, 2024 matter, Lordship. Next week, any date, Lordship, I will get the instruction. In fact, today itself, I will contact the director, Lordship, to give an instruction, Lordship.
No, can we take up the matter at 2 o'clock today? In the meantime,
Yes,
My lord.
Yes.
Because otherwise, my lord, several judgment passed by your lordship and our high court have
Yes,
now being matter.
At 2 o'clock, yes.
Item number 10.
Lordship, I'm sorry, item number 5, Lordship has,
No, now we are not calling the item number 5, item
No.
number 10.
my name may be reflected in the order, my lord. I was
Sorry.
Lordship, time being, sir. Saraswati is coming. Time being, sir. Lordship has come. Lordship.
Well, this matter came idea before your worship also, madam.
Yes.
About the madam change of the game after the game is over, madam. Rule was made that 90% marks, your worship can take remembering, madam. It is a post for assistant professor. And your worship kindly see that office memorandum, my lord. Page 19, your worship kindly see, page 19. Page 19.
19.
Yes.
Yeah.
90 serial number 4. Postgraduate. So 90%, if somebody gets 90%, my lord, he will get 30% in the my lord, as per academic record, my lord. Now this has been changed. Your loss will find page 22.
Yes.
Your loss will find that postgraduate in partial modification of office memorandum dated so and so. They want to notify the following revision in the guidelines for selection of assistant professor, government law college, revision of calculation of marks of postgraduate. Postgraduate more than 80%, my lord. Now they have been reduced to earlier 90%. If somebody gets 90%, he will get 30%. 30 marks, my lord, not 30%. Now they have been reduced to just if somebody gets 80%, he will get my lord 30 marks. Your lordship order is also very clear, my lord, in that case, my lord. Earlier also, your lordship also once gone through this record, my lord. So now our case is, my lord, because this notification, this memorandum, it has come subsequent to the selection process started.
Okay.
This is the only case, my lord.
Okay.
On that ground, my your lordship.
Now you tell me when the advertisement
Yes.
was published.
Yes, that was 2/7/24.
2/7/2024.
Page 21.
2021.
Page 21. In 21, an office memorandum, you'll also kindly have a look to page 21. Page 21, my lord.
Yes.
Here, your terms and conditions, your lordship will find in the advertisement printed copy, my paper.
Yes, yes.
Terms and conditions, terms and the educational qualification and selection procedure will be as per government office memorandum number so and so dated 24/1/22. Your lordship got it.
In which part it is mentioned?
Page 21, serial number 2 below terms and conditions. Terms and conditions, middle, right side, my lord. Right side is the situation back in Monday, Ancholic College, Monday.
Got it.
Terms and conditions,
Okay, this 24/1/2022.
24/1/22. Now
Okay.
kindly have a look to 24/1/22, page 17. Page 17. This is a 24/1/22. It says your loss will find that
So at the time of advertisement, this office memorandum was in force.
yes, exactly, my lord.
And subsequently.
And in
it
the
was-
advertisement, they have stated selection will be as per this office memorandum. Be very clear, my lord. Then, my lord, this second office memorandum come page 2, subsequent one. It has come on 22/10/24. After the application, last date was over also. 22/10/24. এটা হবে দিছিলাম ওটা
Yes.
Your lordship,
That is your case.
madam?
That is your case.
That is, this is right. And your lordship's order is kindly have a look, your lordship's order, madam, where is the stay was given 18/11/24. Your lordship's order.
Yes.
Last.
Hmm.
So this is my case, my lord. Now matter is coming, they have also submitted my lord, that warning body, etc. Matter is not pending, it is not yet, it is now stopped because of your lordship order, my lord. Now matter is getting delayed because of non-disposal of the case, my lord.
Okay. Yes, Mr. Towelder, what is your stand?
In this case, Lordship, the initial advertisement, Lordship, the mandatory qualification for Lordship, assistant to appointed as assistant professor is Lordship master's degree along with net and slate, Lordship. So, Lordship, in our case, Lordship, the mandatory qualification has not been changed or altered before the interview. Interview is yet to be started. Also. The process, that is the 90% to 90 marks, the 30 marks to 90% and above has been partially modified to 80% and above candidates also. So this partial modification, the Lordship authorities have every right to select a candidate as per their Lordship, the requirement, Lordship. So this, the partial modification does not change the Lordship, the mandatory qualification. So there is no Lordship discrimination, nothing has been taken place till now, Lordship, and the rule of the game, the changing of rule of the game will not be applicable in this case, Lordship. In that regard, Lordship, I have already, in my affidavit, I have clearly submitted, Lordship, may come to page 25 of my affidavit. It is not that the petitioner will be barred from appearing in the interview. We have changed the process, that is partially modified the process, Lordship. That doesn't amount to changing the rule of the game. And Lordship, page 25 of my affidavit, paragraph 6. May I read the paragraph?
Yes.
That the office memorandum dated 22/10/2024 issued by the Higher Education Department, Government of Assam is only a partial modification of the government office memorandum dated 24/1/22 issued file number so and so stating the guidelines for selection of assistant professors, librarians in provincialized government and model college of Assam. The partial modification of the earlier one dated 24/1/2022 is to the effect of awarding of marks and attendance of nominees. These two conditions were modified. Awarding of marks and attendance of nominees of by a VC through online mode only but same has not changed the eligibility criteria of the candidates, and as such, partial modification does not affect the selection. In this context, Lordship, I have already submitted one judgment of the Honorable Supreme Court. It's there, Lordship. In the case of Lordship, the state of Uttar Pradesh versus Karunesh Kumar.
It is not available on the record. Can you furnish a copy?
Lordship, have got only one copy, Lordship. I can.
One copy.
Paragraph 32, Lordship, please, that. Paragraph 32.
32, yes.
Lordship, paragraph 32. Paragraph 32, may I read it? The respondents have also placed limits on the decision of this court in the case of K. Manjushree Supra. However, in our considered view, the facts of the aforesaid decision are quite different from the present case. A change was introduced for the first time after the entire process was over. Based on the decision made by the full court for the cutoff. Secondly, it is not as if the private respondents were non-suited for participating in the recruitment process. The principle governing changing of the rules of game would not have any application when the change in USNG is with respect to the selection process, but not the qualification of the eligibility. In other words, after the advertisement is made, followed by an application by a candidate with further progress, a rule cannot be brought in, disqualifying him to participate in the selection process. It is only in such cases the principle of aforesaid will have an application, or else it will hamper the power of the employee or to recruit a person suitable for a job. So, Lordship, this says that the mandatory qualification cannot be changed. It does not debar the petitioner to participate in the selection process to be started, Lordship. So here we have only the, as per the employer, that the suitable candidate, only the marking system and the video conference part that I have read in my affidavit. So in this case, my humble submission is that rule of the game.
No, the problem is whether you can change the marking system after the advertisement being published.
Lordship, always he can participate. It doesn't mean that any effect will cause to that Lordship person.
We'll pass the order. Heard Mr. Isa Sodure, learned senior counsel assisted by Mr.
A.M. Alongir.
Learned counsel for the petitioner, and Mr. Law Builder, learned standing counsel for the higher education department. Argument concluded, order reserved.
All right. But I may be allowed to furnish a fresh copy of the judgment. That is a rough copy I have.
Yes, you can.
Another judgment you have given last time is maybe the Tej Prakash, my lord.
I have not seen here.
Tej Prakash.
It is not available in the case.
Oh, last time you have given in the file. No.
Yes, I had also submitted.
No.
I'll
Then also.
provide the soft copy, I'll provide
You
the soft
furnish a copy.
Madam.
Yes, I'll provide.
Our only case might have the form 90%, somebody is to accommodate it. This is their case.
Okay.
Obliged to law.
All right.
For bail hearing, item 11.
Maybe. This is second application, Millard. Earlier it was rejected for 3, 1 was granted. Ground Millard, the investigation was probably it is completed. And Millard, the statement of the earlier it was not examined by your lordship. Only the medical or CD was read. And the way LCR has come, Milord, scanning copy, so your lordship may kindly consider.
Yes, have you gone through LCR?
Yes, my lord, I have gone through the LCR, my lord.
Is there any material?
My lord, there is a 183 statement, my lord. The victim implicated this persons, my lord, regarding that part. My lord, here the case is that though the POXO is added, my lord, the search sheet is filed against the present accused petitioner under 120 BN 307. Kindly peruse that part. Otherwise, medical part is also there, but they are the injury parties. I didn't get my. But the implications is there, my lord. But see, may I read the, my lord, only, that is the relevant part from the vernacular of the FIR, my lord. That is only, my lord, relevant part, my lord, I am reading in the vernacular.
Page number?
My lord, page number 11, my lord. Annexure 1, page 11 of the petition, my lord.
Yes, sir.
Below, my lord, it is my lord, that is the middle of the, my lord, paragraph. Moi sure Bakor Korab, Eknong Podokia. Now, Eknong Podokia is not before us, my lord. The Rustom Ali is not against him, POXO edit, my lord. বাকি পদকীয়াজনক মাতি আনে আৰু সকলো মিলি মোক হত্যা কৰি পেলাই দিয়াৰ উদ্দেশ্যৰে মুখ বন্ধ কৰি লাঠি ৰড আদিৰে মাৰধৰ কৰি গুৰুতৰ জখম কৰি ৰছীৰে গলত চেপি হত্যা কৰাৰ চেষ্টা চলাই আৰু গলত ৰছী লগাই ভেন্দাত ওলোমাই দিয়ে যাতে মোৰ মৃত্যুক আত্মহত্যাৰ ৰূপ দিব পাৰে কিন্তু এনে অৱস্থাত কেনেবাকৈ ওচৰ চুবুৰীয়াই আগবাঢ়ি আহি সিহঁতে মোক মৃতপ্ৰায় অৱস্থাত ৰক্ষা কৰে মানে দিস ইজ দ্য এলিগেশন.
And medical report, I have seen there is no physical injury on her. I have seen it.
Here, my lord, that is the informants council is also appointed, my lord. Mike up at the same time, my learned, and he is also kind of.
I have been appointed by your lordship as the legal aid counsel, but at the same time, he has also filed a Wakalafnama on behalf of the.
Okay, okay.
Very good.
But Mr. Vishwas,
Yes, sir.
perhaps mistakenly the private secretary has written your name here as A. Vishwas.
Yes.
In fact, it was S. Vishwas. Your name is not in the list
It has
also.
come out that way. That is what I was, I was
Yes.
not mentioned in the list, so I was totally surprised, but I have received a copy.
Your name is not there in the list
That
prepared
is,
by the
that
registry
is
office.
what I was surprised
yes.
when I received it. They said that no, your lordship had appointed me. So
Anyway. Yes, have you gone through the?
yes, I have gone through it, your lordship.
Yes, so what is
Now,
your submission?
The thing, as my learned colleague has stated, the 180 means the statements which has been recorded under 183, which my learned colleague has stated that with there in the CD, as well as the statement given by the informant in her FIR, has already been taken note of by your lordship in your lordship's earlier order rejecting it at page para 8 of that particular earlier order. Annexure 6 is the earlier order passed by your lordship rejecting the earlier bail application. And if your lordship kindly come to page 22, at page 8, your lordship, para 8, page 22.
Yes.
Here, your lordship will find your lordship's clear observation with regard to the 3 applicants before your lordship today. That in view of the material so far collected in the case diary, especially in view of the statement of the victim girl recorded under such and such, and also in view of the nature and gravity, this court is of the view is not a fit case where the privilege of pre-arrest bail granted to the applicants number 1, 2, and 3. They are the same applicants before your lordship. Now, applicant number 4 was enlarged on bail by your lordship. Now, going through it, there is no new material they have brought on record from this earlier observation of yours, lordships, that to consider this because on the same sets of facts they have come. And another thing your lordship will find, as my learned colleague has pointed out, annexure 2 at page 13, your lordship will find the first observation from the Dhubri Medical College Hospital. The diagnosis is clear case of alleged hanging. And it corroborates the statement of the informant that she was being forcefully tried to be hanged by the other accused along with the main accused who is not before your lordship. But this already corroborates her statement. So I feel that your lordship should not exercise your lordship's power to grant them pre-arrest bail because a late girl has been made to suffer. And another aspect, your lordship, they had tried to bring that she is married. But if your lordship takes up the same page, at page 13 itself, the name in the column where name of father, spouse, guardians are there, it is totally blank. So as on 23/7/23, the name of the alleged accused number one, who is not before your lordship, they said that the accused number one and the informant were married. That is also not being substantiated by their own document, your lordship. They are trying to bring on record, these are facts, but I feel your lordship should not exercise your lordship's power to grant them bail, your lordship. Because this is a serious offense against.
Okay. Yes, Mr. Das.
My only submission is that, my lord, since this is second bail application, my lord, so there must be some specific new grounds, my lord. I could not file a single new ground, my lord, in their petition, my lord. And that alone, my lord, should be a ground for rejection. No new grounds.
Yes.
Whatever materials are there, my lord, your lordship had already considered in the previous time, my lord, previous occasion, my lord. So subsequently, in the new petition, my lord, they could not furnish any additional ground. So that is my only submission, that this is not a fit case for consideration.
Okay. Okay, we will pass the order.
Only my submission, my lord. Earlier, your lordship, medical report was not there. And LCR was not there. And these two materials probably are before now your
No,
lordship.
no, this page number 13, is it not a medical document? It was issued by the Dhuri Medical College Hospital.
My lord, yes. That is, my lord, yes.
This is
that-
your document.
Yes.
Here it is mentioned, it is a case of Alice hanging.
Alice hanging, it is, it means that it is not hanging. Alice hanging may not be hanging, may be hanging. It is mentioned by the victim. But when it was examined by the doctor, my
No,
lord,
no, not mentioned by victim, it is the diagnosis.
but in the kindly similar medical report. Medical report is there, my lord. The recalcitrant, my lord. Nothing. No medical injury, my lord. No injury in the medical report. I have seen, my lord. And on, my lord, the section POCSO Act is, my lord, averted. That is apart from other thing. And we against us, my lord, there is no any, my lord, allegation against POCSO. Only, my lord, the accused number one, he is not before lordship, and him, my lord, that POCSO Act is maybe inflicted.
Okay.
And we resided separately in separate house. They are said separate house. But now they are, my lord, bringing us, my lord, in the same
Okay.
column. So, my lord, there is also one woman, my lord. So your lordship will make only that good.
Okay, we'll see.
Must.
Hello.
Item number 12.
May I feel this of Lordship, my lord? Lordship, kindly go through the, my lord, order passed by this honorable court, my lord. My lord.
Dated?
Dated, my lord. 31/3/2016. 11 parties, my lord. Page 10, my lord. There are 4. 8. My lord, may I read, my lord?
This all regarding release of salaries, Lordship. I have given an instruction from the secretary. What has happened? Petitioner was appointed initially against a non-existent post. He was continuing, he has approached this honorable court, court has directed the certain direction to the department Lordship. Now, the present incumbent has been included later on. Now, after that Lordship, what happened? That he was adjusted a post against a vacant post. And to pay the area salary, Lordship, a supernumerary post has to be created because he was appointed against an non-existent post, Lordship. So for that, Lordship, proposal has already sent to the finance department. Finance department returned the file on Lordship 13/3 regarding to submit some checklist and to get the views of judicial department. So judicial department view has been taken. It was the judicial department furnished their views on 24/4/2025 lawsuits and directed the department to comply. Accordingly, lawsuit the department has submitted to the finance department again on 28 for creation of superannuation post and also a supplementary demand for rupees 24,81,700 lawsuits. That is for the area salary. And to pay that area salary, post has to be created because he was appointed against a non-existent post. Now he has been readjusted against a vacant post lawsuit by the director. Recently, I have submitted the copy to the petitioner also. They have joined in their new post lawsuit. And to pay the current salary, I have received an instruction from the DO. Lawsuits. Since the salary was stopped from November 2010, lawsuit till date, his GPF accounts is not active. So now bill was submitted to the treasury officer. Treasury officer has objected that
For current salary.
for current salary. Now he will fall in the OPS, old pension scheme, not the new pension scheme. So that has to be corrected in the finance department. So this process is also going on. It's the instruction from the district lawsuit. Because his EPF account is not active lawsuit, treasury objected. And now the DO has written to the director for lawsuit. Now I have just contacted, have a telephonic conference with the director that he will fall under the OPS, earlier old pension scheme. So that has to be corrected lawsuit. So this process is going on. It is not the department is sitting lawsuit, as because he was appointed in non-existent post, the salary could not be released. A post has to be created, and it is presently pending in the finance department lawsuit. We have also given a supplementary amount of 24,81,000 lawsuits to pay his area salary. He will get lawsuits as soon as lawsuit. Now he has joined in a new post lawsuit, a vacant post. We have adjusted him.
Mr. Sestry,
Yes, sir.
without deducting his GPF, whether his salary can be released.
That is the treasury officer objected. That's what I have learned from the conversation lawsuit. Because DPF account has to be there. A bill was submitted lawsuit by the DO, but treasury officer, he said that you have to, the DPF account has to be correct, activated lawsuit. Because it is an, his GPF account is not in active lawsuit.
So earlier the petitioner had a GPF account.
There is a specific direction from this honorable court, my lord. Subsequent, when the contempt matter has been declared, no face verification is necessary. Problem is that, my lord, there is a here and there, my lord, file going here and there, and this contempt matter is pending, my lord, long back, my lord.
Not only finance department, not anywhere, only finance department. lawsuit.
Only I want to submit my case. Yes, my lord. What is the order from this honorable court, my lord? Has. Page 9, my lord. I am coming, my lord. In this instance, it is indisputable fact remain that petitioner has been rendering his service as assistant teacher of Aradhul Milan Nagar lower primary since 1989, counting from initial date of appointment, and thereafter as assistant Granuladay lower primary school since 1990 with a regular time scale of pay. Have you also got it? Regular time scale of pay.
I have seen it.
Yes, all has
Sir,
been.
No, Mr. Sodhuri,
Yes,
the two letters produced by Mr. Sestry,
yes, my lord.
it appears that they have been taking some step to implement the court's order.
My humble submission earlier also they produced. They said that everything has been approved. Subsequently, they taken back their stand, my lord, and another department will come. That is why I want to submit one thing. 21/6/2024 passed by this honorable court, my lord. Because tomorrow they again stand their position, my lord. I shall satisfy your lordship. 21/6/2024. Have your lordship got it? The lordship kindly look that order, man.
Dated?
Dated 21/6/2024. Hart Miss P. Das Larner, standing counsel for the respondent, has played on recommendation commission dated 26/2024. Wherein it was provided that jurisdiction is now carried to verification with regard to the appointment letter and also verify the existence of the name of the petitioner in a district data record to ascertain whether the vacancy against the petitioner's claim have been appointed existed. It is to be noted that the court had ordered that the 31/3/2020 directed the Director Elementary Education to release the salary. That order, my lord, main order. The petitioner including the area salary with effect from March 2011. There is no further opportunity to the department to carry out any fresh process verification was provided. Accordingly, it is not understood as to how the light of direction passed by this honorable court had ordered that the 31/3/2000 verification process as indicated communication dated 26/2000 is carried out. Giving a last minute to the respondent to comply the direction of the honorable court, 31/3/2000 registry is directed to list the matter again 24/7/2024. My humble submission before your lordship, there is a specific direction from this honorable. You paid the writ petition, everything has been discussed. Thereafter, review has been filed by them and that was withdrawn. Everything has been discussed. There is a specific that you paid 3 months. Then there is this specific order. Why you going to each time verification? Each time verification, I found that I was working. I am not on that because I am arguing on contempt cases, my lord. Now I am arguing on contempt cases, my lord. Thereafter, my lord, another order. Justice Jotang decision.
No, Mr. Sorure.
Yes, my lord.
You see the letter.
Yeah, I am not getting that letter, man.
This joint secretary to the Dr. Vasan. Letter 28/4/25.
Yes, my lord. Your lordship kindly look to the another order passed by this honorable court, my lord, 28/2/2025. I want to source one thing, my lord. 28/2/2025. My humble submission, 3 months has been gone, my lord. Last 7, 6, 7 years, this way, my lord, this contempt has been, my lord, flouted by them, my lord. Para 4, my lord. SMT system, have a look at it, my lord. 21/2/2025. So and so, letter number, so and so, Joint Secretary, Government Assam Education, with reference subject set and continuation earlier government letter. OP, I am direct to state the supplementary proposal, 24 lakh for payment of the investment petitioner. Muhim Kaur in the instant case was moved to finance budget by letter number so and so 67. Finance department has approved. Have you also got it? That approved the supplementary demand 24.82 lakhs. Does it mean, my lord, finance department has already improved each and every time they are coming with new document, my lord, saying that we are need this thing, that thing. Yes, I leave to your lordship, my lord. Nothing has been given. The current salary, not financial areas, nothing has been given today.
Mr. Siste, have you furnished a copy of the letter dated 25/4/25 to him? Issued by the Block Elementary Education Officer.
The earlier one, no, this one, yes.
No, this earlier letter dated 25/4/25.
Demand has already been approved, my lord. Earlier demand has already been approved, my lord.
No, for payment of your current salary,
Yes, my lord.
the treasury officer could not clear the bill because of your GPF account number is not active now.
My lord, GPS, what I understand, my lord. GPSL, my lord.
No, GPF.
Yes, Government Provident Fund, my lord. They can do one thing, my lord. My GPF account, I have to take instruction. That has already been existence, my lord.
Not active.
As per my Gogoi, my lord, my friend Gogoi, that account has been there, my lord. They said not activated. They can do one thing, my lord, GPF amount, they cut the GPF amount and other salary shall be paid. And we can active the GPF account, my lord, anytime. But
no, that's all right. But where they will keep the fund for allotted for GPF account?
My lord, honorable submission before your lordship that suppose, my lord, the GPF account was not activated. That is one part of the salary they shall get cut, my lord. Does it mean, my lord, they will not Anything to the petitioner, my lord?
No, 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 no.
GPF account
Technical
আছে।
difficulties are there.
Huh? GPF account not active নাই নেকি? He said it was active, my lord.
Already existed, the GPF account is there.
No, existed and active are two different proposition. Your account may be there, but as per this letter, it is not activated.
Because from
Only
2010,
today
he did not
they
receive
have
any
said,
salary.
Only today they have said, my lord. And one thing is that GPF are activated by them, my lord, not by me, my lord. As per,
Mr. Sisty, you do one thing,
Yes, Lordship.
my lord.
you obtain instruction from the treasury officer whether without deducting that amount of the salary can be paid.
Yes.
We'll take it up at 2 o'clock.
I will ask my file.
In the meantime, you obtain instruction.
Yes, your lord.
And you also obtain instruction what step he has taken to activate the account.
Yes, ma'am. Activate, I cannot activate, my lord. Department will activate.
That's all right. You
ma'am.
have to take a step
I do করবা, huh? Yes, ma'am.
at 2 p.m.
Yes, oblige you.
Item 13.
Item 13, Lordships. The present inspector school has already submitted the proposal to waive the access road to the pension on 28th of April. This is the landmark, Lordship. On earlier occasion, Lordships, the the inspector of school, Lordship, here in the
Lordship, the inspector of school, Hailakandi, has been called. There is a personal appearance today, and he has not appeared.
by virtual. It was written in by virtual order. But he was wrongly made a party because he has transferred on August 2024 Lordship, and this contract was filed in the December 2024. So by the time he has already been relieved from this post, Lordship. The yellow flag Lordship may kindly fail, Lordship. And that is why this honorable court has directed the respondent, the inspector of school, Lordship, earlier to appear in virtual mode, Lordship. But it was all, but the present inspector has already been sent. Now it is pension department, they will do the needful for waiving of that access royal Lordship.
No, what is the case?
Lordship, they have raised an objection, Lordship, because of the wrong fixation. Lordship, they wanted to recover an amount of rupees 2,14,433. This honorable court by judgment, Lordship. Lordship may kindly see the judgment at page 19. It starts with page 15. It's a long judgment, Lordship, covered by Lordship Rafiq Masih's case, Lordship, that it cannot be recovered unless there is a involvement of the petitioner, and there should be an inquiry. And that writ petition was disposed of, Lordship, long back on 1/5/2024. And Lordship, I have retired in the year 2021, but till now, Lordship, the pension has not been given to me. It is a covered case, Lordship, and this my writ petition was.
No, where is that judgment?
Judgment at page 16, Lordship.
Yes, Mr. Sisty.
Yes.
Law is well settled.
Yes,
that
now
there
we
is
have
nothing
already,
about that.
yes, we have already proposal for waiving that access amount to the pension department. The pension department, they will take the decision, Lordship.
Oh, where is the order? It be an order?
That black mark, Lordship.
At page 16, Lordship.
Page?
Page 16.
Page 16 is the order.
Yes.
No, no, impugn order.
Impugn order is at page 13, Lordship, 14/6/2019. Recovery of wrongful. This is, sorry, Lordship, this is an office memorandum. Impugn order to lower nine. Page 11, Lordship. Page 11. Resubmission of original service book and pension papers of Tapaswi Nath. With reference to the subject cited above, I have the honor to submit herewith the original service book and pension papers of Tapaswi Nath, retired assistant teacher. Pay as on 1/4/2024 15 has been corrected and refixed at rupees 41 and with effect from 1/4/2016 to 13/9/2022 with due entry and attestation has been made in the service book. For excess drawal recovery of pay statement of the retiree is enclosed herewith for necessary deduction from the DCRG amount. That amount is reflected at in page 12 also. 2,14,433. And even if there is any wrong fixation lawsuit, that is not attributable to the petitioner. So I'm covered by the decision of Rafiq Masih. That is why lawsuit this honorable court has disposed of my case by referring to.
And it will not be lawsuit deducted. It will be where the department has already taken the decision. Only the inspector of school, he has to submit the proposal to the finance, to the pension. As he was not done, that was lawsuit that order was issued by to the inspector of school. But
No, we are setting aside this interim order. You cannot recover the amount.
No, we are not going to recover lawsuit. Already the proposal has been made. Lawsuit may kindly the flag mark lawsuit. I have the yellow flag. That proposal has already been made to the pension for waiving of that excess amount. We are not going to deduct it, Lord.
Lawsuit, this is I'm in contempt now. Lawsuit that has already been set aside.
That has been set aside, lawsuit.
That has already been set aside.
Now we have to implement it, lawsuit.
Okay.
Yes. And that proposal has already been filed by
That
the
order,
inspector of school.
the honorable court's order is at page 15 also. It starts from page 16.
The pension department has to take a decision to pass the final order lawsuit. The yellow flag letter lawsuit.
No, pending this the pending clearance of this proposal, you pay her the pension and other amounts of which here she is entitled to, legally entitled to.
Yeah, that will have to pay. Yes. I will get the instructions also.
Also, I have been paid only the GPF amount and the other retired dues such as gratuity, leave encashment is not yet paid. Also.
That instruction I will take. And in the meantime, pension department will also take the instruction. Let it come on next week, lawsuit, any day. Or after 2 weeks, lawsuit.
No.
And next week.
So there was a direction to comply with the order of the court within 60 days. Order was passed on 1/5/2024, almost a year over. So what other step you have taken for releasing her other benefits? You have taken a step for waiving the excess drawal amount, that's all right.
Yes.
But what step you have taken for releasing the other pensionary benefits to the petitioner?
High School.
Who is for Directorate of Pension?
Director of Pension, my
Mr.
friend.
Deuri, what happened to the pensionary benefit of the petitioner?
For this excess drawal issue, your lordship, perhaps it is.
No, we are not concerned with the excess drawal amount now. What step you have taken for releasing other pensionary benefits to her?
Lordship, due to the non-furnishing of all the proper documents, your lordship, we could not, the Director of Pension could not proceed. Now, since newly on 25th, your lordship, as I informed, the proposals today morning also at the conversation, they told that it has not been received by the director. So, as per, I do pray for the next week for all the up-to-date instruction, your lordship, because this due to excess drawal issue, the matter. Now, since your lordship has viewed it correctly that leaving this issue whether all others can be in the meantime be paid or not.
Yes.
So to that effect, let me have the instruction made. Your lordship, please fix it in next week.
Okay, that's Next Monday then. Heard Mr. Das, learned counsel for the petitioner and Mr. Sisti. For contempt number, you have a contempt number one and Mr. David for number two. Contempt number two. During the course of hearing, Mr. Sisti has produced two letters issued by inspector of school addressed to the Directorate of Pension, Assam. Then the other letter to the Director of Secondary Education, Assam. Waiving the excess royal amount of rupees 2,14,433 rupees. A copy of the aforementioned letter is furnished to Mr. Das to obtain necessary instruction, and also Mr. Deori, learned counsel for the respondent number two. Contender number two shall obtain up-to-date instruction as to what steps are being taken to release the other pensionary benefit of the petitioner. List the matter on Monday.
Lordship, Lordship, I have a small favor. May I pray for a communication that has been received by friend, a copy of that to me,
Yes,
so that
yes, yes,
I can correspond with the. And meanwhile, Your Lordship, I humbly next Wednesday or Friday it may be, because I may be out of station. Maybe the next Monday.
Wednesday.
Okay,
Wednesday. The letters for this before the court today shall be part of the record.
Obras. For hearing item 14, parted matter.
Lordship, this both the trial court as well as the first appellate court decided the matter on the point of tenancy. Therefore, I'd like to submit my submission on the point of tenancy more first, and
on the point of
tenancy only, tenancy. At page 23, trial court framed issues, certain framed issues, 4 number of issues. Whether the suit is maintainable in the present form, whether the suit is bad for non-general of necessary parties, whether the plaintiff has rightful interest over the suit land, whether the plaintiff is entitled to relief as prayed for. No, both the suit as well as appeal has been decided on the point of tenancy. Wait. But
Yes.
no issue was framed on that point of tenancy. Generally, issues are to be filed by the respective draft issues are to be filed by the respective parties. Thereafter, the trial court analyzes that frames the issues. So no issue has been framed on that point. Secondly, no issue was framed in respect of defendant's case. It is entirely on the plaintiff case issues were framed. Let us see again whether the suit is maintainable in present form, whether the suit is bad for non-general necessary parties, whether the plaintiff has rightful interest over the suit land, whether the plaintiff is entitled to relief as straightforward. No issue was framed on that point of in respect of defendant's case.
Whether that was in your written statement.
That was there. We took the plea. Tenancy. We are protected under sector.
You show me the written statement filed by you. Is it part of this record?
It is part of the record at page 52.
52.
Para 3, that no cause of action arose on the suit for the suit, that the plaintiff have claimed the suit land on the have been vested with the defendants as arrears since 2000. And as per Assam Temporary Settled Areas Tenancy Act 1971 and under section 5 of the defendants are occupancy tenants of the suit land under the plaintiff. So therefore that plea was there, that tenants are protected. trial court decided the matter at page 24. I heard it is in the last para. I heard the counsel, learned counsel of the parties and perused the record carefully. I find that defendants are not the occupancy tenants. That means either occupancy tenant or tenant. Occupancy tenant or non-occupancy tenants. But there is a question of tenancy has come. And the plaintiff has claimed under the section under the said Assam Temporary Tenancy Act, and the plaintiffs are adheres under 2001 to 2003, which is less than 3 years. Moreover, this is a suit for declaration of right title interest and so on, so on, so. That means again it is that. Now the appellate court also. Now let us come to the appellate judgment at page 19. Page 19, exactly on 21 line. At 21 line, it will come. It is, of course, correct that the plaintiffs had not been able to link their relevant documents. There is some inconsistencies in the patta number and DAG number, but this, in spite of this, it emerges from the available documents and coupled with the oral testimonies that the plaintiffs have right to interest over the suit land. Now, question the Ladakh appellate court himself stated that there is inconsistencies with their documents.
Paragraph number?
Paragraph, it is 20, paragraph 20 at page 19. It is, of course, correct that the documents that the plaintiff have not been able to link the relevant land documents. There are some inconsistencies in the patta number and DAG number. But in spite of this, it emerges from the available documents coupled with the oral testimonies that the plaintiff had interest over the suit land. That means the appellate court also took it that one that there was inconsistency in the documents. That they were not able to link their earlier patta with the present patta. Let us come to the Assam Tenancy Act. Tenancy Act, Land Laws of Assam, 3, volume 3. What is occupants? Volume 3, chapter 2. Classes of tenants. Occupancy tenants, chapter 4, chapter 3. A person who is for a period not less than 3 years has been continuously held as land as a tenant shall have the right of occupancy tenant of the land. The question here is that, again, it is their plea that we came into the tenanted land in the year 2000. We stayed there up to 2003. We paid the revenue arrears at this. 2004 we defaulted, and the suit was filed in the year 2007. Either in a default condition or otherwise other condition. We continue to remain as a tenant. It is more than 3 years. Even they are counting their own period, 2001, 2002, 2003. It is clear 3 years period. Therefore, both the courts below stated that I am not a occupancy tenant is not correct. They say that I am non-occupancy tenant. All right. Now, non-occupancy tenants, occupancy tenants have all the right. It is a stringent act. Occupancy tenant has all the transferable, heritable, all these rights. But non-occupancy tenant, at chapter 5, a non-occupancy tenant shall have the right of possession till he is lawfully ejected and subject to the other provision of the act, or any customs or tenancy shall be rescinded in the same manner as the movable property. Now, non-occupancy tenants, if had to at the 19, protection against the ejectment. A non-occupancy tenant shall not be ejected except as provided under chapter 9 of this act. Let us come to the chapter 9. Chapter 9, ejectment. Section 50 is not required. So let us come to the section 51, grounds for ejectment. A tenancy, a occupancy
Chapter-
tenant,
chapter?
chapter 9, section 51. Have you got it, Lordship?
Grounds for ejectment.
Grounds for ejectment. An occupancy tenant shall not be ejected by his landlord from his landholding except on execution of a decree of for ejectment passed by on the ground that he used the land comprised of his holding in a manner which renders it unfit for the purpose of tenancy. Now, second, any tenant. Now, the lawmakers did not say it is occupancy tenant or tenant or non-occupancy tenant. It is tenant. Shall not being occupancy tenant. That means it comes to us. Shall not be ejected from the land of his tenancy except the execution of a decree for ejectment passed on any or more of the following grounds, namely, the grounds are there. That he has used the land comprised of his holding in a manner which renders it unfit for the purpose of this tenancy. Here is not the case. It is nothing to do with this instant case. Second, that he has broken the condition of his tenancy with the provision of this act and on the breach of which he is under the terms of the contract between him and the landlord liable to be ejected. This is the ground that we did not pay adi. That he has failed to pay the rent, the third extra C. That he has failed to pay the rent. This is the third one, C. That the land is bona fide required by the landlord for his personal cultivation. They did not take the plea that it is required for cultivation, personal cultivations. No suit for ejectment on this ground shall be entertained before expiry of 12 months and after expiry of 15 months from the date of creation of tenancy. So they are, as per their own statements, we were there 2001, 2002, 2003. 2004 also continued to remain, 2005 also continued to remain, 2007 they instituted the suits. So the terms and condition, it is the specific period is given, 12 months after expiry of 12 months and not after expiry of 15 months from the cessation of the tenancy. And provided that if tenant has nowhere else to go, here the land at 10 because he shall not be ejected on the grounds unless he has been, this is not the case. Now, let us come to the 54, section 54. Procedure for ejectments. And this is exactly the substantial question was formulated on this point. Whether the suit of the plaintiff for eviction of the defendants is barred under section 54, subsection 2 of Assam Temporary Settled Area Tenancy Act 1971. Procedure for ejectment. No tenant shall be ejected from his holding except by execution of a ejectment decree passed by competent civil court, and the relevant provisions of the civil provisional code shall apply to such proceeding. No problem. There is no problem. The exact procedure has been followed. There no suit for ejectment on the grounds of mentioned as the section 51, 1, 2, A, B shall be entertained unless the landlord has filed a notice upon a tenant requiring him to the remedy or to pay the compensation for misuse or breach of complaint of our tenant has failed to comply within the 1 month of the accepted notice. Here is the case. They have not exhibited any document to show that notice, mandatory notice. This is the must. Notice has to be issued. No such document has been given to us. Now, it is their case that we are tenant. So mandatory issue, this must be issued to me so that I can reply.
So whether you have raised all these issues
Yes,
before the
yes,
learned trial
learned
court as
trial-
well as master
learned-
court?
I should clear the.
I know what he is going to do. He is going to talk about my WS. He'll get the time.
Your lordship may peruse the written statement itself.
I know what he is hopeless.
He has claimed his ownership right over the land.
All right.
So how he can claim
All right.
contradictory stand on the basis of the tenancy?
Let him submit. I'll submit later.
Just for clarification, because the finding of the court itself, there is a finding that he is not an occupancy tenant, nothing else. Because he has claimed the ownership right on the basis of a registered deed That is mentioned in paragraph 2 of the written statement. Your lordship may peruse this page 44.
Page number?
Page 44. Once he denies the title of the landlord, claiming his own title, then how he can contradictory stand on the basis of the tenant?
It is the defendant's case. Defendant can take contradictory stand also. Defendant has the right to take both
I
contradictory
have
stands.
not heard of such laws, my lord, before.
I can file,
No,
I'll
no,
file certainly.
there is
rulings
a
to that.
decision of Supreme Court that they can take contradictory stand also.
There is no bar. I can file 100 rulings to that.
Contradictory stand they may take, but what has been substantiated by themselves, my lord. They have shown one sale deed, my lord. So, if they are owner, then how they can become, my lord, the tenant? And
It is their case. It is not my case. It
Section
is court's.
116 also says, my lord, of the Evidence Act. Such stand they cannot take.
It is their case that they took the plea that we are tenant
Just,
on that.
I have pointed out, my lord, let him
Alright.
finish his.
Okay, let him finish, yes.
Now, let us go that this notice, whereas mandatory notice, no suit for execution on the ground of pension in the section 51, subsection 1, 2, A and C shall be entertained unless the landlord has first served a notice on the tenant requiring him to the remedy, including payment of area rents, or has to pay compensation for misuse or breach of complaint, and tenant has failed to comply within 1 month from the receipt of the notice. Thirdly, after issuance of the notice, he has to wait another 1 month. Thereafter, he can file the suit. There is no such notice. It is their case that we are tenant. So notice on this ground alone is this. Their suit should not have been decreed. Second, at this ground, we took it in our appeal, first appeal, as well as the title suit also. We title suit we are protected under section, protected by Tenancy Act of 1971. That's all. Because law is not to be elaborated. We need, law is not to be declared. What defense we supposed to take, we took that plea. Let our WS, yes, it is admitted fact that the WS was a hopeless one. In spite of that, now the learned trial court should have framed an issue that there was a document, certified copy of the sale deed, that some issue has to be formed. Yes, that particular document, sale deed did not carry any right. The learned court below did not give any findings on that sale deed. Therefore, because as both the courts, trial court as a first appellate court did not consider my defense in altogether in the trial as well as appeal. Therefore, raising at this second appeal by them that I have a sale deed, because that suit was decided, appeal was decided on the point of tenancy only. So my submission before this only on the point of tenancy. So this is now what remedy is. Suppose he has given, notice was not issued. Ultimately, notice is issued. Now suit is filed. In that case, what suit they could have filed is that rent suit. Let us come to the next substantial question of law. Whether suit for eviction against the defendant could be filed on the ground of default for payment of rent without filing a suit for under section 34 of the Temporary Settled Areas Act. Let us come to the section 34. When a rent is due for repayment, the cash rent shall become due for rent fortnight from the earlier than that of corresponding land revenue, which is payable by this landlord, becomes due for the payment, or where the landlord is not able to pay the revenue, he would be able to pay it issued by him. The corporate shall be due from the day of 60 days from the date of harvesting crops. Now, evidence has to record. Evidence is recorded. They should have laid evidence that this crops was planted. 60 days passed. Rent was not given to us. They just said one line that they used to pay Adi. 2001 they paid us Adi. 2002 they paid us Adi. 2003 they paid Adi. In the year 2004 they failed to pay the Adi. In that case, already I have that first hurdle is already over. 3 years already I stayed there. I paid the rent as per their own statements. Now it is that area rents shall not be paid when it falls due, shall be deemed to have an area. Now question of filing rent suit comes under rent suit 36. No area rent shall be realizable other than by a rent suit filed by the competent civil authority. Now only when I failed to pay the rent, first rent, they should have gone for rent suit. In the event rent suit is decreed or otherwise decreed in favor of them, in that case, what is my duty as a tenant? I should pay them 5 times of the land revenue. Suppose it is 5 rupees, I need to pay only 25 rupees to them. That's all over. Because it is stringent act in favor of the tenant. The procedure for such rent shall be according to the provision of civil procedure code, and the plaintiff shall in this matter so and so, so and so. Now here in this case, they did not file any rent suit. Declaratory suit can be filed, no problem, but not against the occupancy tenants, not against the, and if it is filed against the occupancy tenant, even non-occupancy tenant also, there are, it covers under the section 51, subsection 2, 54. So therefore, my interest is fully protected in spite of the fact that I took another plea that I have a registered sale deed. When both the courts below, courts as trial court as well as appellate court did not give any findings as regards to my sale deed, as regards to my mutation order, as regards to my Jababandi copy, even as regards to my this one also. What is it called? I have been paying land revenue. They have not paid any land revenue. They have only filed their certificate. Certificate is a different one. Land revenue received is different one. Certificate issued by Gamboda or Mojadar that so and so land revenue has been paid. So that is only a certificate. Land revenue, since their time, period time, during the pendency of the suit, appeal, until today, they have not given any document to show that they have been paying their rent. Therefore, my second appeal, I humbly pray before the Honorable Court to decree my second appeal because of disorder clause. Section 24, Section 54, subsection 2, and Section 34 of the said Act, Tenancy Act. Now, as regards to my, I already said contradiction, a contradictory view, I can take it. When the court, both the courts decreed the matter, dismiss the appeal on the point of tenancy, therefore all those points raised by them will not, because they have to submit only in respect of in the point on the point of tenancy, because it is their plea, not my plea. Lordship. Yes, Mr. Soror.
And so the findings of the appellate court, my lord, and at page 12, my lord, I am reading my lord. The point number 1.
Page number
12, my lord. So far the maintainability question, my lord, the learned trial court committed grave illegality in deciding the issue number 1, that is whether the suit is maintainable in the present form. The plaintiffs have claimed in their plaint as well as their evidence that the defendants were tenants under them since 2001 to 2004, and they paid due rent up to 2003 but failed to pay the rent for the year 2004. The plaintiff asked the defendants to vacate the tenanted land, and as defendants failed to vacate the same, they instituted 145 CRBC proceedings and subsequently brought the suit in the year 2007. Therefore, present suit is maintainable under the Assam Temporarily Settled Areas Tenancy Act 1971. In deciding this issue, the learned court will fail to consider the law as the plaintiffs claim that the defendants were tenants under them. Therefore, the declaratory suit for right title interest is clearly barred under Section 51(1) of the Temporarily Settled Areas Tenancy Act, what has already been submitted. Once the plaintiff themselves claimed that the defendants were tenants, the learned trial court could not have held that the defendants were not tenants. The learned trial court observed that the time period of 2001 to 2003 is less than 3 years, and so the defendants are not occupancy tenants, whereas as per plaintiff and evidence the plaintiff themselves, the defendants continue to remain as tenants by paying rent, etc. up to 2003, and they defaulted to pay the rent in the year 2004. Therefore, the plaintiff should have filed rent suit and not declared receipt, which is clearly bad. But the learned trial court overlooked this important aspect and illegally decided the issue of maintainability in favor of the plaintiff. Decision and reasons therefore. In course of appeal, hearing the learned advocate of the appellant defendants argued that as per claim of the plaintiffs, the defendants were cultivating the suit plan as their defendants are adheres from 2001 to 2003. And therefore, the defendants were admittedly non-occupancy tenants, at least if not occupancy tenants. And in view of the provisions contained in section 51(2) of Assam Temporarily Settled Areas Tenancy Act 1979, non-occupancy tenant cannot be ejected from the land of his tenancy except in execution of a decree for ejectment passed on any one or more of the grounds mentioned in subclause A to D. According to the learned advocate, neither the grounds mentioned in the subclause A to D is affected to the facts of our case, and as such, it was open to the plaintiffs to only institute a rent suit against the defendants. According to the learned advocate, the plaintiffs instituted a declaratory suit against the defendants rather than filing a rent suit, and the learned court below totally overlooked the fact of that a declaratory suit is barred under the Assam Temporarily Settled Areas Tenancy Act 1971. But I am not convinced with the submission of the learned advocate for the defendants. The issue of maintainability of the suit was framed taking into consideration the pleadings of both the sides. The defendants in their written statement to dual stand, inasmuch as on the one hand they stated that as per claim of the plaintiffs, they were tenants, adheres under them, and under the Assam Temporarily Settled Areas Tenancy Act 1971, they were protected against ejectment, and on the other hand, they took to stand that the defendant number one had purchased the suit land by way back in 1968, in the year 1968, by a registered sale deed. Taking this fact into consideration, the learned court rightly observed that the title of the plaintiff is clouded as defendants are claiming right title and interest over the suit land on the basis of the registered sale deed and mutation. My lord, here the submission made by my learned opponent that that issue was not framed, not discussed at all. That is not correct submission, because entire in decision and reasons it has been reflected. But even the trial court has decided, adjudicated that issue of the my lord. Only my lord, here stand has been considered because considering both the parties, my lord, the materials on record, the court will decide, my lord. Accordingly, the maintainability of the suit that has been decided in favor of the plaintiff. And now the question comes, my lord. The section, I refer 116 of the Evidence Act, my lord.
Section
116, my lord.
Stopel.
Estobel. Estobel of tenant and of license of persons in possession. No tenant of immovable property or person claiming through such tenant shall during the continuance of the tenancy be permitted to deny that the landlord of such tenant had at the beginning of tenancy a title to such immovable property, and no person who came upon any immovable property by the license of that person in possession thereof shall be permitted to deny that such person had a title to such possession at the time when such license was given. So if he has taken the stand that he has purchased the land. So where is the question of tenancy, my lord, by virtue of it, my lord? So, my lord, both the trial court and the appellate court has decided the issue so raised before the court regarding tenancy aspect of the matter, that was diluted, my lord, and it was with a clear finding, it was said that the suit was maintainable. And accordingly, this aspect of the matter was decided by both the court below. Now, so far the title of the plaintiff, my lord, that has been decided in the finding, my lord, at page 19, your lordship will find at paragraph 20.
Paragraph 20 of
The appellate court's ruling. Furthermore, I am of the view that the learned trial court has rightly held, after considering the documents adduced by both the sides, that from exhibits 1 and 2 of the plaintiffs, it becomes clear that the predecessor in interest of the plaintiffs had title over the suit land, and that from exhibit 5 also it is clear that the plaintiffs have right title interest over the suit land. The defendants have taken the ground in this appeal that the plaintiffs have failed to establish their title by linking the relevant land documents exhibited in this case. It is, of course, correct that the plaintiffs have not been able to link the relevant land documents. There are some inconsistencies, chapter number and DAG number, but in spite of this, it emerges from the available documents coupled with the oral testimonies that the plaintiffs have right title interest over the suit land. It has to be borne in mind that in civil cases, the standard of proof is not proof beyond reasonable doubt, but proof by preponderance of probabilities. It would be appropriate on my part to quote here a few words of Lord Denning. If the evidence is such that the tribunal can say we think it more probable than not, the burden is discharged. But if the probabilities are equal, it is not. This is a finding of facts, my lord, of both the courts below, my lord. And at this stage, my lord, that finding of facts, my lord, the question of interpretation.
That's all right. That is well settled. But the question is, none of the court below has formulated any point on that tenancy.
My lord, the issue has not been framed, my lord. Evidences are there, and adjudication in the my lord, regarding maintainability of suit, everything has been adjudicated, my lord, regarding the issue of tenancy, my lord. And it has been rejected by the court below that since they have taken stand of purchase of the land on and the title they have claimed against the landlord, so they are stopped, my lord, under section 16 to claim as tenant, my lord. That is the on that basis, my lord, the whole suit was deciding the maintainability of the suit. Of course, there was section 116 implication that has not been discussed in the judgment. So I leave up to your lordship, my lord, regarding this, my lord, on the basis of that this plea was rejected regarding tenancy, and it was decided on the issue of title of both the parties, because title was claimed by the defendant and title was claimed by the plaintiff, and plaintiff's title that has been decided with the reasons that the plaintiffs could prove his case. That is the case. So, my lord, these substantial question of law are not substantial question of law for adjudication of this case, my lord, at this stage in the second. Already, this is my
only one submission. Supposing I did not have written statements, except only one ground, that the suit is not maintainable under under the Act of Tenancy, Act of 1971. That's all. Because I don't need to explain anything. One. Secondly, when both the courts below did not give any findings to my registered sale deed, therefore the court gave only findings on the point of tenancy. Therefore, question of my right over by way of registered sale deed, etc., does not come, because that right I have still open for me to adjudicate, because I have a registered sale deed when both the courts below did not give any findings. Whether I did not have a, because 30 years old document also. Thirdly, even they also claim that Suitland was purchased by them. They did not produce any. They have given explanation. Yes, very old document, 1938 document. Therefore, I could not produce it. That's all. There, and when there is the substantive law is there, 71 Act is a substantive law, whereas Evidence Act is a procedural law. When substantive law is there, substantive law will prevail only for the purpose of doing it. When both the courts did not decide the matter on this one, or the only on the point of tenancy. Therefore, Tenancy Act will prevail. Look.
Whether that decision is available with you, that you can take a contradictory step.
And that I'll get tomorrow, day after tomorrow, I'll file it. I have the document. I have, because today hurriedly I was rain. I was soaked with the rain. A certain thing I could not collect it because of the shot that it was raining. When I came out from my home.
Okay, you produce it when? Day after tomorrow.
Day after tomorrow, sir.
Okay, we will keep it as part.
A lot.
But on that day, we will not hear any of the party.
All right,
You have to
Lordship.
submit only the.
All right, Lordship.
Okay. Heard Mr. Bhagavati, learned counsel for the appellant, and Mr. Soduri, learned counsel for the respondent. List the matter on Thursday as part third.
Lordship.
Number 15.
Will be the lords. Well, what happened, my lord, same issue is pending before the division bench, my lord. Since, my lord, the issue has been already decided. So may I pray for, my lord, listing of the matter subsequent to,
After some time,
my lord.
some days.
Today is fixed for, my lord, before the division bench hearing,
Today?
my lord.
Okay.
After 1 month, my lord.
After 1 month. Mr. DJ Soikia, learned counsel for the petitioner, that's for listing the matter after 1 month.
Right.
As connected matter is pending before the division bench.
Today, my lord, in court number 6, my lord. Listing.
Division bench of this court. List the matter after one month.
Oblige, your lord.
Item 16.
In this case, for earlier order, from our side, approach the petitioner side to settle the dispute, my lord. For settling the issue, my lord. Outside the court, my lord, but they have not responded. Petitioner side has not responded. Lord.
Can we compel them to settle the issue outside the court?
Lord, my instruction is otherwise. I have approached my senior friend's client, my lord, but they have not responded, my lord. So, my lord, better we can, my lord, go for the hearing and the law will decide. My lord. My lord, matter relates to, my lord, initially, my lord, compassionate family pension scheme, my lord. My lordship is well aware, my lord, that the compassionate appointment has been abolished by the government. And in that lieu, my lord, a new scheme under the compassionate family pension has been introduced. And under that scheme, my lord, till the, my lord, the deceased employee continue with the service, my lord, is entitled to the salary part, my lord, as per the last salary he received on the date of his death. And thereafter, my lord, on superannuation, it will convert it into, my lord, family pension scheme as per the Assam pension rules of 1969. Now, my lord, when we filed the writ petition, my lord, at that relevant period of time, the deceased employee's service was continuing, my lord. So therefore, the salary component, my lord, the family is entitled to that salary part till the date of superannuation. Now, after the superannuation, now, my lord, we are entitled to the compassionate, to the normal family pension, my lord. That is the law. Now, my lord, what has happened? The private respondent herein, my lord, is the second wife of my deceased father, my lord, and who is, she is now, my lord, enjoying the my lord, an attempt had been made, my lord, to take the all the benefit of the family pension by depriving me, my lord. I am a minor daughter, fully dependent on my father, my lord. Now, therefore, my lord, I have been represented by before my lordships by my elder sister, my lord, who is the, my lord, petitioner number 1 and 2 has joined together. Because, my lord, being a minor, I cannot come directly before my lordships, my lord. So therefore, my lord, this honorable court has passed an interim order that till the issue is decided, my lord, that the family pension should not be released to anyone, not myself, not to my mother, my lord, who is happened to be the second wife of the deceased, my lord. Now, that is the, my lord, at that stage, my lord, this petition lies, my lord. Now, when the several hearing had been done before this honorable court on the last occasion also, my lord, this honorable court directed that whether there can be any amicable settlement of divide the pensionary benefit amongst the parties or not. Now, my lord, my instruction, my lord, is that from our end we have tried, my lord, but it could not be, my lord, settled in that manner, my lord. So, my lord, can decide the issue, my lord, on the basing on the relevant law, my lord. My lord, recently, my lord, a full bench of this honorable court, my lord, in Janufa Bibi's case, my lord, has settled the, my lord, family pension that whether the second wife is entitled under the Mohammedan law or not. But, my lord, here is a case wherein, my lord, the daughter, the dispute between the daughter and the second wife, my lord. Now, whether that judgment will cover the entire issue or not, that is also an issue, my lord. Paragraph 22 and 23 of the Janufa Bibi's case, my lord, is very elaborately explained, my lord. So, my lord, that judgment, my lord, can peruse, my lord, if it helps, my lord, in the cross, my lord. And before that, my lord, I beg to draw my lordship's kind attention, my lord. To a, my lord, notification dated. My lord, may kindly turn to page 26, annexure 3, petition copy 9.
Page number?
Page number 26, annexure 3, my lord. This is the scheme, my lord. The scheme for compassionate family pension in lieu of the compassionate appointment in short, called as the compassionate family pension scheme. My lord, skipping the first. My lord, can
No, that's all right.
my lord.
That
My
is
lord.
there.
That is there, my lord. Now, another important point, my lord, in page 27 point clause 5.10. 5.10, my lord. At page 27, bottom part, my lord. My lordship has got it, my lord. It is also provided that if the parents or other eligible family members are not looked after by the compassionate family pensioner on receipt of such complaint from them, the competent authority will issue orders apportioning the compassionate family pension appropriately amongst the other eligible family members. Now, my lord, here is a case wherein, my lord, I being a dependent daughter of my late deceased father, my lord, my part has not been apportionate by the government nor by my private respondent, my second wife, my mother, my lord, stepmother. So now, my lord, basing on this clause 5.10, my lord, the family pension could have, my lord, they have apportionate it, my lord. We have also approached the authorities also, my lord, to invoke the provision of this provision, but that has not been, my lord, done till date. Now, my lord, whether I am entitled or not, this is another notification at page 29, annexure 4, has also, my lord, has been notified, wherein my lord, even after the attaining the age of 21 years, my lord.
Page number?
Page number 29, annexure 4, my lord. This is a notification by which the my lord, pension rule has been amended, my lord. In exercise of the power conferred by the provision to Article 309 of the Constitution of India, the Governor of Assam is pleased to make the following rules. Further to amend the Assam Service Pension Rules 1969, hereinafter referred to as the so and so. This rule may be so and so. My lord can skip the first part, and provided I am bringing my lordship's attention to this proviso part, my lord, provided that the family pension shall be allowed to continue beyond 21 years of age to an unmarried dependent daughter of a government servant oblique pensioner, subject to the fulfillment of the following conditions: that there is no disabled child eligible for lifetime of the family pension, that a certificate of non-marriage and non-employment in the prescribed format duly certified by the circle officer or block development officer concerned, Annexure 3, shall be furnished by the unmarried dependent daughters to the treasury bank once in a year. Sub-rule so and so. So, my lord, from this amendment, my lord, the provision has been made the subject to fulfillment of these two conditions, my lord. The unmarried daughter is also entitled to the family pension. Now, here is a case, my lord, wherein I am a student, my lord, till my studies are going on. I was fully dependent on my father's income, my lord, my father's salary. Now, my lord, that has not been paid, my lord.
Okay, you are referring to paragraph number 22 and 23 of the judgment.
No, yes, my lord, the full bench judgment, paragraph
Bench judgment,
22 and
22
23.
and 23.
My lord.
Mr. Sigdar, you go through these two paragraphs and you appraise this court. Are you agreeable to settle the matter in terms of this terms of the observation made by the three judge bench of this court in this judgment?
My lord, the paragraph 22, may I read, my lord? We further hold that it.
No, Mr. Sigdar, you go through the same and you obtain necessary instruction from your client and appraise this
My
court,
lord, so far,
whether they are agreeable to settle the matter in terms of this
my lord,
observation.
so far my instruction I have received, my lord. My client has approached the petitioner side, but they have not responded. My lord, his submission is reporting that he had made request to me and I have not responded. That is not correct, my lord. If lordship is saying, then we can
My
make
lord, we
another
can
report.
file an affidavit before my lordships also clarifying the stand of both the parties, my lord. That will be better, my lord, because otherwise this will be a disputed facts, my lord. I approach, he has not responded. So an affidavit will, my lord, bring on record, my lord, that what is our appropriate stand. Either we are allowing or either my respected senior friend's client is agreeable to that or not, my lord, then it is matter will be end there, my lord.
So next week,
My lord,
Tuesday, next Tuesday,
my lord.
okay.
Third week of May, lordship.
Pension matter, my lord. There are some urgencies there, my lord.
Matter. Lordship, on a motion there then.
My lord.
Tuesday,
Hearing matter, Tuesday.
Tuesday.
My lord.
All these are same lordship, 6, 8, 13, 15, any day. All are of same, same load. Load is same.
Okay, say 6th of May then.
6th of May.
My lord.
6th of May.
May.
Third, Mr. Air Bhuya, learned counsel for the petition.
6th May.
Then Mr. Sigdar, learned counsel for the respondent number 6.
My lord.
You for respondent number 6.
My lord, I am
No,
respondent number 9.
6 or 9? 9, sorry. Then Mr. Sharma, you are for?
Respondent number 2, 3 and 4.
2, 3 and 4, and Mr. Deori for respondent number?
1 and 7.
1 and 7.
Preparing for respondent number 5.
Mr. Your name, please?
On behalf of Mr. Steve.
Learned counsel, appearing on behalf of Mr. Sigura for respondent number
5.
5. Easy. Okay. 13th part, release the matter on next Tuesday. So as to enable learned advocates of both the parties to obtain necessary instruction from their clients and to place the same before this court.
And my lord will.
In respect of the observation made by this court in
Paragraph.
In paragraph number 22 and 23 of the decision in Zonofa BB, which is Begum Muhammad versus Fatma Begum Muhammad and others reported in 2023, 1 GLP MD 736.
Lord, and file an affidavit to that extent. That will.
Okay, fine. And to file their affidavit, clarifying their stand.
Mile. Oblige me, file your.
17.
This matter, I pray for little accommodation to the lordship. Mr. K. Gogoi, lordship, he has got some difficulty today, lordship.
Mr. K. Gogoi.
K. Gogoi will argue this with her, lordship. Post of Gogoi, lordship. So, lordship, some difficulty is there on our part.
Okay. Or Mr. NNB Sodore, learned counsel for the petitioner, and Mr. Towilder, learned counsel. Appearing on behalf of Mr. K. Gogoi, learned standing counsel for the respondent authorities.
Higher education.
Mr. Respondent authorities in higher education department. Mr. Towilder, learned counsel, submits that Mr. Gogoi will argue the matter and he is not available today and tries for listing the matter after a week.
My lord, can it be last week of May, my lord?
Last
I
week
have
of
some.
All right,
Can you go to yes,
29.
29 May.
Lordship, he is available, he is available here, but due to some personal difficulties.
So, due to some personal difficulties, he could not argue the matter today and tries for listing.
It may not be recorded at
some other day. Here, look. This is the matter of
29th May.
29.
Item 18.
In this matter also, I have talked to my senior also, lordship. Mr. Gogoi will argue and lordship, my senior sir will also file some affidavit as far as.
My lord, these petitioners before this honorable court were the part-time lecturer of a particular polytechnic colleges. Part-time lecturer. Thereafter, the government decided to do full-time, but they were given a fixed pay of 72,000. Fixed pay of 72,000. Our whole case is that equally situated like us, equal work, equal pay, but they were under 3F, which they were getting a pay scale, 3F. Now recently, we are also being converted under 3F. Our whole case before this court was before conversion. Our whole case was that why we have denied equal pay, equal work, equally like that of 3F. Now recently we have also been converted into 3F. So I'll bring notice to the court that we have been converted into 3F also. So at least we should get a.
File an affidavit then?
I'll file an affidavit, additional affidavit.
Bring on record.
Before now, bring record to the court.
Third, Mr. Tidas, learned senior counsel. Assisted by Ms.
Yes, sir.
Learned counsel for the petitioner and Mr. Towilder, learned counsel for the standing counsel for the respondents in higher education department. Mr. Das, learned counsel for the petitioner, submits that after filing of this petition, the status of the petitioners changed. Status of the petitioners have been changed, and they have been appointed under 3F, regulation 3F. Regulation 3F, and it may be granted some time to file an additional affidavit to bring on record the aforementioned facts. There is accordingly allowed. When?
After 2 weeks.
After 2 weeks. After 2 weeks. Accordingly, it is provided that SSL is the matter of 2 weeks.
Item 19, order made of.
My lord, here, my lord, one subsequent development I came to know, my lord, yesterday, my lord. The other private respondent number 10, my lord, to whom was also issued a notice, show cause notice. Immediately after the order of the honorable single judge. Then, my lord, that order was challenged, show cause notice was challenged by filing a WPC number 6611 of 24. which was subsequently withdrawn, my lord. So that file has to come clubbed together, my lord. Apart from this, my lord, what happened to the hearing case? Because I was, on the last occasion, I was apprising this honorable court, my lord, why I have been targeted alone. Now we came to know, my lord, notice was to issue to her also. And what director has done? Basically, I have no grievance against the order of the honorable single judge. It is not against me. Honorable court said, while seeing it, you give reasonable opportunity. My grievance is that for which I have filed a writ petition, why particularly me, I was targeted. Now we came to know that show cause notice was issued to private respondent number 10 also. So my prayer at this stage, my lord, I have got an affidavit, my lord, will reply it. We got it on Friday, my lord. So we'll reply by Wednesday. Lordship fix the matter. In the meantime, my lord, direction may be issued to the director, my lord, education, my lord, what happened about the hearing. In respect of the writ petitioner, in respect of private respondent number 10. That record will reveal, my lord.
No, Mr. Borboya,
Yes.
today this matter is fixed for hearing on the preliminary issue.
Of maintainability.
I am not against the order of the honorable single judge. I am not aggrieved.
Whatever may be.
And it has been, my lord, subjected because of the show cause notice was issued to persons. Earlier, I came to know only to me. Now we came to know that the private respondent number 10 was also issued a notice. They challenged it before High Court as show cause notice.
Private respondent number 10, I think by filing an affidavit in this case has also entered appearance.
And
So
he did
whatever,
not disclose.
just 1 minute, for whatever this case or that case, I am appearing for this case. And so far as I am concerned, my lord, what I prayed last day was to take up the issue of maintainability, whether this particular instant writ petition before your lordship on board is maintainable at all or not. Your lordship may hold it that it is maintainable. Then, of course, your lordship will go into the nitty-gritty of the factual narrations. Otherwise, there may be wastage of time if ultimately it is held that no, in the present form, and for this reason, this case is not at all maintainable. Therefore, the question of maintainability may be heard first. That is my prayer. Rest, I don't know. Who filed what case? I am not bothered about that. As long as that doesn't touch me. Now, if we wants to bring some other case to take together, that is his business. I think respondent number 10 is also here. Respondent number
My
10.
lord, one thing, my lord. Honorable single judge passed an order directing the authority while passing order or affecting anybody's right.
Those are many facts.
Facts I'm saying, my lord, from the record, not from my own.
Before all this.
My lord, if it is obstruction, my lord, I cannot make submission, my lord. Either let him complete his submission, then I'll make my submission. It is the everyday routine, my lord.
No,
Mr.
maintainability,
Borboya.
not facts. Facts will come later on. First, first maintainability.
Okay, Mr. Borboya, let us hear on the point of maintainability.
Maintainability, my lord.
Yes.
Then, my lord, honorable court.
Yeah.
Then
Mr.
pass any.
Borboya, please sit down.
Honorable court directed, my lord, to the authority, while passing the order, you give notice, opportunity to the aggrieved person. Aggrieved person meaning thereby, now, my lord, it was impugn order, it reflects against me only. But now we came to know that the show cause notice was issued to private respondent number 10 also. So basically, I am not against order of the honorable single judge which passed the order. I am not agreed. It has not affected me, my lord.
No,
So
no.
far, I am
no,
challenging.
Mr. Borboya, you
Yes.
say the order of the learned single judge is the basis for passing the impugn order.
Yes, my lord. Impugn
have
order, my
taken-
lord. I challenge the impugn order, my lord. Impugn order reflects only about me. Only affects me. That's why I am before your lordship. How come, my lord, the authority has left out the private respondent number 10 despite of issuance of the notice? That's why I am challenging this particular order. That my writ petition is only in respect of this
No,
impugn
no,
order.
no, you
Impugn
see-
order ought to have been passed, my lord, saying something about the private response number 10. But here, my lord, does not reflect despite of issuance of the notice. That's why I am challenging this impine order. Though they have said in persons to the order of the Honorable Court did not say you go and target particularly the instant writ petitioner. Accordingly, my lord, notice was
No,
issued.
may not be, your name is not there in the order of the learned single judge,
Yes, my lord.
but that is the basis for passing the impugn order by the
Yes, my
respondent
lord.
authorities.
Yes, impine order passed in a
And
wrong manner.
in their affidavit also, they have taken a categorical stand.
Then that
On the basis of the order passed by this
the
court.
High Court, and now lordship it is up to your lordship to examine what Honorable Court said. I am not a party to that proceeding.
No, that's
I am
all
not a
right.
party to the proceeding.
No, no, that's all right. Now the question is, can we examine the order of the learned single judge?
No, my lord, I am not onto that, my lord. I have no, my case is not at all affecting my lord. Lordship, kindly have a look. The Honorable Court said what, my lord? Assuming for the moment your lordship has directed the authority to go and examine and you give reasonable opportunity. Your lordship did not mention any name. Me also, because I'm not the party to that proceeding. While passing, my lord, the impugn order basing on the order of the Honorable Single Judge is the wrong interpretation, because, my lord, the law is equal before all. Honorable Court did not say go and target particularly Mr. J, particular person. They have issued notice also. They have also issued notice also. Now I have no remedy. I cannot go review also. I cannot go for appeal also.
Why?
Because I'm not a party, and firstly, an honorable single judge.
No, no, that order affect your right.
No, my lord, but whatever I understood from the order, my lord, it does not affect me, my lord, in any way.
You may not agree, but they have taken their stand.
Their stand, I am challenging before that, my lord. They might have filed the affidavit, because once the government passed the order, they will not say that it is the wrong. They passed the order firstly, then again withdrawn, then again passed the impugn order, saying that in the name of particular case. But that case, I'm not a party. I'm not a party. Had it been name of some other else, then we could have gone for writ appeal or review. But here, my lord, the honorable single judge did not mention to whom to target. There is another teacher also, my lord, who has occupied the benefit, my lord. That's why I'm challenging this one, my lord. And GP appointment is not considered. Let it remain, my lord, in the order. And their appointment also, my lord, it reveals that, my lord, appointment was given in persons to the notification they have annexed by themselves, my lord, private response number 10, 161 page. Yeah.
So your party is over that.
No, my lord, not yet over, my
No,
lord.
on
If I have
the
not,
maintainability. We are not
maintainability
carrying
is
on the
that, my lord, I am saying, my lord, lordship will have to call for the record of that case. Then your lordship will go for hearing. Lordship fix the matter
No,
on
regarding
after tomorrow.
maintainability.
That writ petition number, my lord, lordship fix the matter on.
We will call for the matter, call for that record.
Yes,
By that, we agreed that this petition is maintainable.
It is a maintainable, man.
According to you, it is
It
maintainable.
is maintainable according to me, according to in persons to the order passed by the court, my lord.
Okay.
It does not affect me, my lord. Lordship kindly call for the record, my lord. 6611 of 24. Then your lordship will make up the mind, my lord, about the maintainability.
No, first let Mr. Barbara submit.
Lordship will call for the record, my lord, 6611 of 24. In that case, my lord, show cause notice was issued to me also, to her also,
6611 of 24.
of 24. That, my lord, they have challenged particular notice, show cause notice issued by my lord in persons to the direction of the honorable single judgment.
Okay.
But that part, my lord, they have withdrawn the case. I don't know what happened later on, my lord. Then, my lord, what happened? Only impugn order reflects me, my. Does not say anything about the private response number 10, whether their appointment is correct or not, my lord. So I am challenging basically the impugn order which subjected by though in the name of the honorable court's order, but it reflects something different. In that view of that, my lord, the writ petition I have to file, I have to challenge particular writ petition.
Okay. Yes, Mr. Barbara.
My lord, if your lordship decides, so far as the maintainability is question, I think one who raises the question of maintainability speaks first and submits first before.
Okay.
And after hearing that, if your lordship finds that no, yet another particular file is also necessary to be tagged, then only your lordship will take it. Otherwise not. How relevant that is one number 10. He filed a case, he withdrew it at his own volition. How far it is related to this, your lordship will see if necessary only. Otherwise not. Already, these cases, the basic civil rule, learned single judge's order and the pleadings are called for, the contempt petition has been. But now let me start with the maintainability question. Why this instant civil rule filed by my learned friend in the present form is not maintainable under the law and also in facts. My lord, I have raised the question of maintainability, and the first question first should be answered first to save time, if not for anything else. Lordship may hold it maintainable. But if at all your lordship holds that it is not maintainable, why waste valuable time by going into the detail of nitty-gritties and submissions and counter submissions with regard to facts and other things? Am I clear, lordship? Firstly, the impugn order is a speaking order, which is a composite order. Passed as per findings, observations, and directions given by, whether he was a party or not, I will come to that. That file is here, learned single judge. As per findings, observations, and directions given by a particular learned single judge in his judgment and order, and after considering my entitlement to provincial. Learned single judge gave his findings. And pursuant to that, this impugn order has been passed by. Secondly, the writ petitioner could have and ought to have preferred either a review petition or a writ appeal against the judgment at least months before issuance of this speaking order. I'll show when. At least months before passing of this particular impugn order, which is under challenge. He has not challenged one another crucial order. I'll, by way of an affidavit, I have. My lordship may take up the copy of the writ petition 4041 of 19. That has been tagged.
Yes.
Kindly take up the copy of the writ petition. There.
Yes.
Lordship, I will kindly have a look at the cause title and prayer. Cause title. What? I filed the writ petition mostly against the government, right from the chief secretary, principal secretary, commissioner education to the my lord finance and director higher education, and the college authority represented by petition. This is mainly infringement of my fundamental rights, my legal rights, principles of administrative fair play, legitimate expectation, violation of the provisions of 2011 governing provincialization of service of the petitioner. These were my prayers, and come to the prayer portion, which your lordship will find at page 19, 18 and 19. in the premises, it's humbly prayed that your lordship will be pleased to admit this petition, call for the records and issue a rule calling upon the respondents to show cause as to why a writ of certiorari shall not be issued declaring the impugned action or inaction of the respondents in not provincializing service of the petitioner. Number one, I am asking for a certiorari for declaring their inaction for non-provincializing my promotion in spite of me being qualified in all aspects. And a mandamus directing the respondents to provincialize the services of the petitioner. I have never challenged any of the provincialized teachers, colleagues of mine working in the college. Therefore, I had no occasion to make anyone a party respondent, either this respondent number 10 or this petitioner, and there were two other lecturers. Am I clear, Lordship? This is what my precisely was the prayer. Now, there was an additional affidavit also filed in that case. Your Lordship will, in the same file the additional affidavit, which I filed. It's okay, isn't it? Just 1 minute, Lordship.
But my learned friend is entering, my lord, into the merits of the case.
No, maintainability I am showing.
Only for the.
No, maintainability. Why he didn't go into the other remedies?
Why shall I go, my lord?
Lordship,
There is the other person, my lord, why action has not been taken?
No, those are facts. Why it is not maintainable?
Not fact, my lord, this is the record.
Mr. Parvai, please.
Let me. He will reply to the question of maintainability after I finish. He will have every right to reply my maintainability after I finish. Page 9, there is a chart. Additional affidavit, my lord, filed by me in that case. Oh. Page 8, my lord, Lordship will find annexure B. It is annexure B. Has your Lordship got it? Yes.
Yes.
Page 8, my lord, it was letter by the principal of the college. Principal means ex officio, secretary of the governing body, to the director of higher education. Submission of teaching and non-STEAM. This is a letter of November 2020. Submission of teaching and non-teaching staff position. Reference to subject, I have the honor to forward the teaching and non-teaching staff position to our college for favor of your information and necessary action. Next page is the position. Start. Teaching and non-teaching position. Lordship will see. Not implemented. Sarath Setia, assistant professor. Third column, date of joining is there. Sapna Gogoi, date of joining 2. Next, it is me, Porinita Bora, 2003. Next, number 4, date of joining 2005 is the present writ petitioner, instant writ petitioner. Position is 4. Here, my lord, the right hand side, I am not provincialized. Others were provincialized. Then respond number 10 is also there. 13. See the 13. This is Assamese department, elective Assamese. There is a system called separate department called elective Assamese, provincial. So therefore, after I place this before this court, when by judgment and order, the learned Singh will just pass in judgment and order. And I'll take your lordship to the judgment and order. In the same file, I think your lordship will find the judgment and order. I want them to there. No? Just 1 minute.
Thank you.
Yes, Pasha. Lordship, the judgment is, I am reading the judgment. Heard so and so, so and so, so and so, so and so. Second paragraph. The petitioner Purinita Bora, that is me, was appointed as an assistant professor in the subject in the so and so college on 2003. The teaching non-staff pattern of the college as provided under the signature of the principal shows that Sarat Sutia was appointed assistant professor 2002. Sapna Gogoi, assistant professor 2020. Pranita Borwa, that is me, Assamese department, 30/8/2003. Protima Setia, that means the present writ petitioner, my learned friend's writ petitioner, 2005, 2 years after me. And in his petition, in a chart, he has wrongly put the date. I will show to that. Admittedly, now this is the position, 1, 2, 3, 4. Who joined first? Admittedly, in order of appointment, the petitioner would be third assistant professor in the subject Assamese in the college concerned. So and so Gogoi Learned Council Higher Education also makes a submission that on the basis of number of students in the subject Assamese in the college is entitled to have 4 professors for being provincialized under the Act 2017. Here, the government advocate submits that there are 4 posts for provincial. Then comes. Petitioner is aggrieved to the extent that against the first post in the Saurabh Setia and the second post of Nagogwe, who were appointed so and so, and Fatima appointed so and so had been provincialized against, but the claim of the petitioner has been left out. Irrespective of whether there would be 4 posts for provincialization in the Assamese department of Hari College, it is noted that 4th person in order of their respective dates of appointment had been provincialized, ignoring the claim of the 3rd person. That is me. The said act itself prima facie appears to be an act which is arbitrary and discriminatory. This is the findings and observations of the learned single judge. Now the government council seeks to justify the same by making a statement that the petitioner did not have the relevant qualification, but when he put a question as to what qualification petitioner didn't have, an effective answer is not forthcoming. I am a master degree holder, net slate. So where I am lacking what qualification? A stand is also taken in the petitioner appointed against excess post. Now, paragraph 9. We are unable to understand the said stand of respondent in as much as the petitioner was appointed on 30/8/2003, whereas Protima Setia was appointed on 15/11/2005, as to under what circumstances the petitioner can be said to have been appointed against an excess post when the 4th incumbent was against a non-excess. This was queried to the government by the government. Further stand taken is that earlier the petitioner was considered to be an assistant professor against elective Assamese subject, whereas others were considered against Assamese subject. Dibrugarh University under memo number so and so to the additional affidavit of the petitioner had provided that Assamese elective subject and Assamese subject are 2 different subjects. Well, there could have been solutions. This 13, respondent number 10, she has been provincialized as elective Assamese. As per the university norm, this college falls under the Dibrugarh University. University norm, 4 posts Assamese and 1 post elective Assamese. There is a separate department, elective Assamese. Dibrugarh University memo provided Assamese. If it is so, last sentence, if it is so, and the 2 subjects are different subjects, a right to be provincialized had occurred in favor of the petitioner, that is to me, to be provincialized as an assistant professor in the Assamese elective subject, but even that was not. I could have been provincialized either against this post or that post. Even no post was given to me, provincial. In other words, respondent authorities, while proceeding with the process for provincialization, had not considered SMEs and elective SMEs to be separate subjects, and both were considered to be a part of the SMEs department itself. Both were considered to be part of the SMEs. In view of above, even the unsubstantiated stand of the petitioner was an assistant professor in the subject Assamese elective cannot be a reason, what the government said, not to provincialize the service of the petitioner, and on the other hand, to give the benefit of provincialization to an assistant professor who is appointed subsequently. My learned friend's client appointed subsequently. From the aforesaid, we conclude, this is the findings and conclusion, that a legal right has accrued in favor of the petitioner for provincialization, but such legal right has been refused by the respondents without any acceptable reason. Then paragraph 12 is the most important paragraph, the operative portion. Accordingly, irrespective of the aspect whether 4 posts would be available for provincializing the service of the assistant professors in the Department of Assamese in Hari College after the amendment of Act of 2017, that means 18. My petition was on 19. Or whether still 3 posts would be available, irrespective of all this. The respondents being the Director of Higher Education Assam to pass a consequential order for provincialization of the petitioner in terms of the Act of 17 within a period of 4 weeks from the date of receipt of certificate. Now, that is one part where after observing that, yes, here is Porinita, this is me, who is entitled and deprived arbitrarily from the provincialization, provincialize her. That is one part is very clear. Now, how to go about that? Learned single, if in doing so, the director is required to pass any further order which may have adverse consequence as regards any other assistant professors. He is not named any other assistant professors who may have been provincialized. In the meantime, the director may do so by following due procedure of law and giving appropriate notice to such persons who may be affected. If fortuitously someone or illegally by superseding or depriving me has been provincialized, the director will proceed in accordance with law. He has not said whether it is response number 3, 4, 5, 6. The director may do so, but at the same time, here again, at the same time, if 4 posts are available and there are 4 assistant professors in the subject of Assamese, as per teaching non-sting staff pattern as provided by the principal, I have shown the chart. We see no reason for adverse order to be required against anybody else for provincialization of the service. Anybody else for provincializing the service of the petitioner. Then where was this scope for me for non-joinder? I claim for my provincialization and very well of the records and the facts. His Lordship discovered the facts and queried the government advocate, then said, no, you must provincialize her. While doing so, if you can find, accommodate 4 of them, then there is no problem, accommodate 4 of them provincializations. I was not challenging anybody's provincialization, Lordship has seen. It is learned single judge who separated the seats from the shafts and arrived at the findings after perusal of the affidavit in opposition and the submissions of the government that, well, if at all there is difficulty, you may proceed any one of them, but by doing so, while doing so, you must do that in accordance with law. That means giving a notice, show cause notice, and the opportunity of hearing. There are Supreme Court cases I will show. So this is how the writ petition was disposed of by the learned single judge. Then when it was not complied, I filed a contempt petition. And in spite of very clear directions and findings by different single judges in the contempt petition, Lordship may come to page 86. Various orders by different single judges. Government passes an order which your Lordship will find at page 86. 86 to control. 86 will be my affidavit in opposition. Contact. My lord, I resume after lunch.
Yes.
My lord, my part, my lord, I'll continue tomorrow or after tomorrow at 1:30. I have to visit doctor, my lord.
Let the other parties continue.
And my junior brother will be there, my lord, whatever. Only one submission lordship will see before that, my lord. When she got the need and when I got.
Mr. Borbaya, you have already argued.
Yes, yes, yes.
But you have to reply.
Yes, yes, I'll
their-
reply, my lord. I'll reply tomorrow, my.
In that case, let him, in his presence, I will argue tomorrow.
Tomorrow.
In his presence.
Tomorrow or after tomorrow.
After completion of argument, he will reply.
Tomorrow.
Tomorrow or after tomorrow, man. After tomorrow. Tomorrow list already out.
So, today you can continue your part.
Today itself.
Yes.
I'll reply, my lord, after tomorrow. Rush.
Item from Itanagar bench. Item 1,
Yes, my
ISCB
lord.
93 of 2025 for orders.
My lord, am I
Yes.
audible, my lord?
Yes, yes.
My lord, this review petition has been preferred by the state, my lord. My lord, in fact, there has been an error apparent on the face of record. My lord, if takes up the review petition, I may show what error has occurred, my lord. My lord's judgment and order, it starts from page 16. This was delivered on 13/6/2023, my lord. At page 21, my lord, para 12, my lord has observed, may I read, my lord, as the issue of entitlement of solicium and interest has already been settled in the case of Mihin Laling Supra, as discussed above, this court is of the considered opinion that the case of the present petitioner is covered by the decision of Mihin Laling, and he is entitled to the same relief granted in the aforesaid writ petition. Accordingly, in terms of the relief granted by this court in order dated 5/4/2022 in WPC number 280 AP so and so, this writ petition stands allowed. It is to be mentioned here that the impugned judgment and order of the division bench passed in WA number 15/2022 and other connected writ appeals, that is writ appeal 16, 17, 20, 21, and 22 and 23, was challenged before the Honorable Supreme Court by the NHRDCL, and by order dated 7/2/2023, the Supreme Court has dismissed the same in the petition in the petitions for special leave to appeal number so and so. My lord, in fact, writ appeal 20 and 21 was dismissed, that which was preferred by the NHIDCL. My lord will find that dismissal order at page 27. Page 27, my lord, Annexure 4. My lord has seen arising out of impugned final judgment and order dated 12/9/2022 in writ appeal 20/22 and in writ appeal number 21/22 passed by the Guwahati High Court. My lord, this is by the NHIDCL, National Highway and Infrastructure Development Corporation Limited versus Jahameto. My lord, by this order, it is of dated 7/2/2023, by this order, the SLP of the preferred by the NHIDCL was dismissed, my lord. This fact has been recorded by your lordship. However, my lord, the fact that at page 23, my lord, the other connected writ appeals, page 23. This was in connection with writ appeal 15, 16, 17, 22, and 23. My lord will see at page 23. Of the review petition, my lord.
Now let notice go at this instance.
Yes, my lord, for condemnation of delay, my lord.
Yes. No, whether the other special leave petitions are disposed of by Supreme Court.
No, my lord, the Mihin Laling case is still pending before the Honorable Supreme
Still
Court, my lord.
pending.
Yes, my lord.
Okay.
And there is a contempt.
While filing those special leave petition, there was some suppression of facts that the earlier special leave petitions were dismissed by the same court.
Yes, my lord, but this Mihin Laling case that preferred by the state has not been dismissed, my lord.
Maybe, but suppressing the fact that earlier special leave petitions were dismissed, those petitions were filed subsequently.
Subsequently, my lord, that is the stand taken, my lord, by
Anyway,
the, yes,
let notice go at this instance.
yes, my lord.
Heard learned additional advocate general for the state of Arunachal Pradesh. His interlocutory application is preferred for interlocutory application under section 5 of the Limitation Act is preferred by the state of Arunachal Pradesh for condonation of delay of 567 days in preferring review petition against the judgment and order dated 13/6/2023 passed by this court in WBC number 56 within bracket AP/2023. Peruse the petition and the documents placed on record. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with ADN also by usual process within a week from today. List after 4 weeks.
Obliged, ma'am.
Number 19 to continue.
Before lunch, I was halfway through on the. You want to say something? And I was as to why the instant petition is not maintained. Of course, it will be your lordship's prerogative to give a finding that it is either maintainable or not maintainable. My submission is that it is not maintainable, for which one of the grounds that they said was that none of them were implemented. I have shown my writ petition that I was not against anybody. I wanted my provincialized. How you provincialize? It is you for the government. And learned single judge gave the observations, he narrated the facts, date of joining of every person, and then put a question. There is no reason on planet Earth why this me could not be provincialized. So, pursuant to that, his lordship said that, all right, if you can accommodate 4 of them, there is no problem. Provincialize me. Retrospective. Prospectively. If at all you see that somebody has superseded me, then you can take action in accordance with law and you must give natural justice. That was the ultimate operative portion of the learned single judge I have shown to your lordship. Now, lordship said within 3 months you do it. It was, I think you can take your seat. Then it was not easy sailing for me. I had to file a contempt petition after 6 months. When till 6 months thereafter, I was not provincialized. And the contempt petition is there, lordship. The file is there. It came before, I am referring only to 2 or 3 judgments, 2 or 3 orders. Written to order. Order. There was one order. 17/5/24. Board even called for the records. 17/5/24. Then the government submits that the process being done for implementation of the order of the simple, not a single judge. Then the matter again came on a matter on 10/2, when the government took time to obtain. Then ultimately 21/2/25, government produces orders provincializing services petitioner in compliance with the judgment and order of the state, based on record, and then the contempt petition was closed. There was also an order by your lordship also, it came before on 21/2/25 order. That was by
Yes,
your
on
lordship.
that day, we closed the contempt petition.
That was not closed. That has already been complied with. The statement was made that already been complied with. So
Yes.
these are the types of orders. Then ultimately the contempt petition. Then lordship kindly turn to when the contempt petition was going on and was pending, there was an order letter which your lordship will find at page 86 of the writ petition.
Present rate petition.
Yes, this is his writ petition. Contempt petition was closed in February, March 25.
Yes.
Before that, page 86, your lordship will find a letter. It was issued on 5th of September 24. One to the president of the governing body, the principal, and 3, Protima Setia. That means this instant writ petitioner. And then me, fixing a date of hearing, inviting reference to subject cited above, I am directly requested to attend office of director, higher secondary, so and so. Without fail, along with all original documents relating so and so. In respect of Protima Bora and Protima Setia of your college in connection with the order dated so and so passed by the Honorable High Court in WPC number so and so. That is the learned single judge's judgment was referred. So at least on that day, it came to her knowledge that, well, there was a direction by the Honorable High Court in a single bench, and as on 5/9/24, this impugn order was not forthcoming. Contempt was pending for not passing an order pursuant to the Honorable Single Judge's order. Definitely, it came to her knowledge that all these orders were as per the directions of the learned single judge. And at that time, she ought to have filed a review petition before the learned single judge, alleging all these things. That I was not made a party. Or even could have filed a writ appeal. Well, this is the learned single judge's judgment. This is the findings. There is something wrong here, something wrong there, something wrong there. I came to know about it. That pursuant to the High Court, a contempt petition is pending. So I am coming against that learned single judge's order. There were occasions where she could have availed. And it is done. There are periods of 30 days or 60 days of filing, but under the eventualities, normally one can go to the court. But I had no occasion to know. Now I have come to know about it, and immediately, therefore, I am challenging the learned single judge's order with all its findings. That was not done.
Even thereafter, along with this impugn order also, she could have gone to the appellate bench. That, well, this has happened as per I am challenging this. Because there was no way when during the pendency of the petition before learned single judge, I could be aware of it. Now, since I am aware because of this, I am challenging this order and also I am making a prayer for a stay or anything of this. This happens. This happens. And this is normally done. Now, this is again a pursuant to the order. It is a composite order passed by a judge, passed pursuant to expressly, pursuant to judgment and order dated expressed by the government. Meanwhile, government made certain dilly-dallies, that is different thing. Pass one order, then we do then under the contempt, under pressure by the court. Bench is taken up the contempt today. Why are you not passing a clerical order into me? Doing the needful, ultimately this order was passed, which your lordship will find that it is a composite order passed to a judgment and findings or directions of a single judge, right or wrong. Rightly or wrong, if I'm allowed to say so. Therefore, lordship, I humbly submit the findings, observations, directions of the learned single judge cannot be interfered with, nor could be altered, nor could be found fault with respect, my lord, by another single judge, your lordship. Because admittedly, and with expressly, every follow-up order has been passed by the government, particularly this speaking order has been passed by the government, pursuant to the findings, observations, judgments, and directions of the learned single judge. Therefore, I think this is not the appropriate forum for them now to assail this composite speaking order for final judicial adjudication on even for interim stay. Your lordship cannot bifurcate the two parts of the orders. One whereby one provincializing me and one withdrawing her provincialization. There are two things as your lordship has seen in the order. I'll come to that. And well, this composite order is a speaking order. Number one, provincializing my service, and number two, withdrawing her provincialization. Both parts have already taken place. Have already been given effect to, as per direction of the writ code and the contempt order. And one crucial order, the instant writ petitioner has not mentioned and not challenged, which I have now, my lord, appended to my additional affidavit dated 1/4/25, which your lordship will find it at running page 128. Yes. Annex A1.
Got it.
Yes, it is 20th February 25. The composite order was dated 22/25. And this was a separate order filed for my provincialization in exercise of authority conferred under so-and-so, 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 17 amended act, pursuant of Honorable High Court's order dated so-and-so in WPC number so-and-so. As per learned single judge order. While letter number subsequent speaking order dated so-and-so by DC. Service of Porinita Borua is provincialized as assistant professor of Department of so-and-so on withdrawal of provincialization. It is the termination or dismissal from service. It is withdrawal of provincialization. Srimati Potima Sethi, assistant professor. She is now employee of the state government with immediate effect. The employee provincialized under this act shall get pay and emoluments as per norms of the state government, as per provisions content, with effect from the present date of joining. Then a format of affidavit was given, which I shown, and my lord, I joined by page 122. 122 minute. Page 122 Annex D. Running.
What?
Page 122.
22.
Affidavit in operation.
Joining report.
Yes. So pursuant to this particular order, whereby I was provincialized, has not been put under challenge. And copy of this was given to all concerned. Copy of this was given to all concerned. So this was not challenged. I am putting it on board by filing an additional affidavit. Now, let's see. Under the circumstances, now the composite order, your lordship will find. Even on facts and law, the claim of the instant writ petition is untenable. Why? Because provincialization of anybody superseding someone senior is always illegal. Here again, the relevant action rules I will have to refer. And for that, if it is detected that somebody has got an 42 regularization or provincialization or illegal provincialization or regulation, and that is detected after serving for some length of time though, more so when it is pointed out by the learned single as well, here is wrong done. Then that can always be withdrawn. The only thing, I have the case laws to show, only thing that she or he must be given a show cause notice and a hearing which has been complied in this case. And there are cases of the Supreme Court also that when certain things are detected, that yes, this man has given illegal promotion or illegal provincialization superseding the other man who initially joined service prior to him, then it can be withdrawn. But these will all require time for placement of facts and the cases. Now, precisely since it is on the question of maintainability, for the reasons I have stated, that another learned single judge, my lord, respectfully, cannot alter or modify when it is personally, my lord, and have a look at the speaking order. What is the speaking order? That is at page 120. No, it is there. Hmm. 87. Writ petition
87, got it, yes.
Yes, page 87 of the writ petition itself.
Hmm.
The instant writ petition. Can you have a look at this? Read the Honorable High Court's order dated so and so, passed in WPC so and so, wherein this court directed and the 12 operative portion of the learned single judge is quoted here. And then repeated.
Not necessary.
Judgment I have read it. Then peruse the speaking order. Peruse the speaking order number so and so 23 number, whereby Director Higher Education disposed of representation of the petitioner, whereas the matter of provincial examine as per provision of the Assam so and so as provision of the 4 number of posts is eligible for any particular subject. It is for government. Once they say it. Whereas the service of 4 incumbents have already been provincial department at Haiti, hence the petitioner service is found access in the Department of Assembly, our service. That is why I approached this learned single judge. But while the order was placed before the Honorable Court in contempt matter so and so, Honorable Court by the order dated 18/12/23 stated that the speaking order available on record dated is not issued in terms of the direction passed by the court, and accordingly same is not given no include. Because before the contempt court, there once there's the
order dated 25th November 20 even, by taking a plea that there are only 4 posts.
Therefore, it cannot be done, then the contempt court said, no, this explanation is not acceptable. Am I clear, Lordship?
And the next paragraph. Whereas Purinita Bora and principal were called for a hearing at the office of the director, I was, whereas under Assam Education Provincial Act of 2011, amended 2012, already service for 4 assistant professors in Assamese department who were provincialized, and the said act has been struck down by the court in WPC so and so in another link case. Whereas the last faculty whose service was provincialized as 4th post in the department of Assamese, namely Purinita Putima Setia, that is her, was so caused.
She was so caused, this writ petitioner.
As to why her service of provincialization dated so and so shall not be withdrawn. Accordingly, Setia submitted her reply.
She filed a reply. It is not that at a one stroke of the pen, it was withdrawn from her. She was so caused that High Court single bench directed this, contempt court directed this. Your pleas are not correct. Provincialize her. If necessary, follow in accordance with law if anybody has to be removed. And she being the last as per the joining,
She was given a so cause and she replied. Accordingly, Srimati Setia submitted her reply, whereas the matter was placed before the government higher secondary for provincial service regard honorable. Whereas on so and so date, higher education issued a letter whereby Director of Education Assam was directed to provincialize the service of the petitioner, namely me, by withdrawing the provincialization of the last faculty, namely the writ petitioner, as per the order of the honorable court, provided the requirement of enrollment. Whereas the enrollment of student department is college is examined, following upon this statement and found to be in order. After perusal of the High Court, this is important, passed in so and so, and in pursuance of the government letter, so and so, service provincialization order in respect of Putima Setia, the writ petitioner in Assamese department is hereby withdrawn, and the service of Purinita Borua is provincialized as assistant professor in the said department under the Assam so and so act. Hence, it is judgment and order. Next page. Why Honorable High Court is
complied. So therefore, under this scenario, when your lordship finds that everything was done as per the, expressly done as per the High Court order, there is a contempt case pending. She talks about non-joinder. I never challenge anybody's provincialization. Honorable High Court took it up from the pleadings and the records and found that I deserve. Honorable High Court said, no way she could not be denied. She could be denied provincialize her. If by accommodating for it's all right. If by not, then you follow the law, give a show cause and natural justice and provincial. Now, if these things have been done as per the direction and observations and findings of this High Court, and in view of the fact that in the meantime, and by the time these impugn orders were passed, she had ample opportunity to go for a review petition or a writ petition, writ appellate petition, my lord. I respectfully submit that this writ petition is not mandated. Therefore, my lord, I will definitely, now I will not go into the facts.
Okay.
Her only submission is that she obtained net slate prior to me. And nowhere in the rules, I can show the education rules. It always says as per the gradation list. Whether you obtained net slate last year and I obtained this year is immaterial. Rules never said it. That is his only point. Even then, everything has been done pursuant to the Honorable High Court judgment, and another single judge, respectfully, my lord, I can submit. cannot take up this matter and decide or nor alter the findings. Lord, that is
Okay.
my preliminary objection. If your lordship is satisfied with that, matter ends here. If your lordship is not satisfied, then I will argue on fact also. Most obliged. Lordship.
Yes, Mr. Das.
Also with regards to maintainability of the writ petition, what my learned senior friend has argued. Also, I am not going to argue that same thing, Lordship. I am just adding that one question, Lordship. This writ petition, Lordship, filed by the Pratima Setia should be dismissed for suppressing material facts and for misinterpreting the provisions of the 2011 Service Provincial Election Act. Lordship, may kindly come to the act, Lordship, at page.
No, we are not on the merit of the petition.
For suppressing, for by repeatedly, he is saying that I did not have the 7 years. That only for that purpose, Lordship. Page 653.
300?
653
650.
of the 2011 Provincial Election Act.
Yes.
Last, Lordship, 4.
Yes.
Employees to be government servant. The services of the employees of all eligible venture educational institutions under Section 3 shall be deemed to have been provincialized on the date of coming into force of this act, and they shall become employees of the state government with effect from the date, provided such institution have completed at least 7 years of imparting education from the date of affiliation, recognition, concurrence, or permission, as the case may be, as on the date of coming into force of this act. Provided that the services of those employees of the venture educational institution eligible for provincialization under Section 3, which have not completed 7 years of their imparting education from the date of their affiliation, recognition, concurrence, or permission, as the case may be, as on the date of coming into force of this act, shall be provincialized as and when the concerned educational institution completes 7 years of imparting education from the date of such affiliation, recognition, concurrence, or permission. In this respect, Lordship, the Hari College, Lordship, they have all the infrastructure, Lordship, and they got permission from the Dibrugarh University, concurrence, all in 2005. They fulfilled these norms of 7 years. So for the institution, it is 7 years of requirement. And Lordship, for the employees, Lordship, may kindly see the definition at page 649. The cutoff date for entry into service.
Yes.
Lordship, may kindly see H, employees. Employees means and includes all serving employees, both teaching and non-teaching, of the venture educational institution who have been appointed by the concerned venture educational institution before the first day of January 2011 and whose services are being or would be provincialized under this act. Lordship, I was appointed in the year 2008. So I fulfilled the requirement, and also our college has also fulfilled that requirement also. So he's repeatedly saying that I did not have 7 years of length of service in the venture educational institution. That is not correct. That is the misinterpretation of the provisions of the 2011 Act. And Lordship, may kindly see, and she was also not qualified when the provincialization took place in the year 2000. The provincialization process started in the year 2011, but when the provincialization order came in 2014, with retrospective effect from 2013, she was not qualified. She did not have net qualification. And Lordship, may kindly see page 655. Provision of the Act, Lordship, 4.3. The services of a teaching or non-teaching employee in a venture educational institution up to higher secondary level shall be considered for provincialization only if they have the requisite academic and professional qualification prescribed by the relevant rules at the time of their initial appointment. So at the requirement was, Lordship, master degree with net or IDA slate. I have obtained net qualification in 2006. I was the only candidate to have acquired the net qualification when the process started in 2011. And there are various judgments of the Honorable Court, Lordship. The rule prevailing on the date of consideration will be prevailed. And Lordship, one more document, Lordship. I am not going to the facts because he will argue. One more document, Lordship. His Lordship may kindly see my affidavit in opposition, which I have. Running page lordship would be page 157.
Yes.
Lordship will find my name, Korobi Gogoi Lordship. The format one qualified list, your Lordship has found, page 157. Your Lordship will find Korobi Gogoi, Assistant Professor, Assamese elective. Date of joining 24/11/2008. Percentage 59.67, net qualified. So there is a process in 2011-12. And Lordship then may kindly come to the next underqualified list at page 159.
No, okay, all right. Since we are
He was
dealing with
in the
question of
underqualified.
maintainability only.
So
These
for
are-
suppressing Lordship and misinterpreting the provisions of the Act of 2011, this writ petition is not maintainable. That is my submission.
Yes, Mr. Towilder.
The speaking order that has been passed by the Director Lordship the government is in compliance of the Honorable Court's order. So Lordship, this is not the appropriate forum to approach Lordship by way of writ petition Lordship. Either they could have gone for review or they could have filed the application. So Lordship, this writ petition is not maintainable. Lordship. In the contempt case also, when we placed our Lordship the order, then Honorable Court declined to accept that and asked us to act in terms of the Honorable Court's order in first in the writ petition. So accordingly, we have Lordship passed the speaking order.
Okay.
Lordship.
Look, if as per decision of the Dibrugarh University, Assamese and elective Assamese are two different departments.
Lordship.
Then, and if in Assamese department there should be 4 posts for provincialization, then why elective is not treated as a separate
Lord.
department?
Elective is not a separate department. The elective comes within the Assamese department. It is the post of elective is within the Assamese. There is not a separate department as per law also.
No, that Dibrugarh University has clarified that it is
But
a
as
separate
per the
department.
statute, that the university may Lordship clarify, but it is within the department of the under the department of the Assamese. Lordship. It is within the 4 posts only.
Okay.
Lordship.
Okay. Heard Mr. A.I. Barmoya, learned counsel for the petitioner. Mr. A.C. Barbara, learned senior counsel assisted by Ms. Learned counsel for the respondent number 9. And Mr. S.K. Das for respondent number 10 and Mr. Towilder, learned standing counsel for higher education department for respondent number 4 and 6. List the matter for further hearing on Thursday? Thursday.
First May.
Always.
Never mind.
Yeah, I have received an instruction Lordship that inspector of school had issued an direct order Lordship, allowing the petitioner to look after the academic affairs of the school as an academic in-source. That order has been issued.
Pick up dated 29th. Right? This order is passed today.
Yes.
So, my lord, your lord, yes, my lord, this matter, your lordship kindly see, I have an challenge and 2 annexes, my lord, annex 11 and annex 12. Academic in charge, my lord, that is their creation. There is no post like call an assignment in charge. I am fighting for my in charge since I am the senior most in charge of the school. Without any reason, my lord, they are not mean. My name was forwarded for the in charge principal, my lord. My lord, I am academic in charge. I don't know what is the meaning of the academic in charge, but if in charge principal is my lord, inspector of school. So it's a very difficult for the school, my lord, running the school. Your lordship, that's why I'm challenging, my lord, that Annex 11 and Annex 10, your lordship kindly see. The judgment not in the all judgment, my lord, passed by the our high court. That yes, my lord, this is fight for the in charge principal. So I'm academic in charge, my lord. That does not mean that he is a principal or in charge principal. My academic in charge, my lord. Academic and that particular is any man they can, my lord, appoint, my lord.
This annexer number?
10 and 11, I am challenging, my lord.
10 and 11.
Page 33 and 34, my lord.
33 is also regarding academic affairs laws, the academic in charge to the respondent lawsuits.
And 34, my lord, because
40 to 47.
Yes.
So your lordship kindly see, my lord, the observation made by your lordship in the judgment of my lord Madhav Chandra Kolita, para 23. It is a very clear judgment passed by your lordship regarding 53A, 51A of AZ, my lord, of the constitution, my lord. That is discussion that. So as a senior most teacher, my lord, I am entitled that, my lord. And without any reason, my lord, they have deprived me. Even, my lord, today they are not giving me. Simply they says that, my lord, why they have deprived me, that is not been answered. Because simply their academic in charge, my lord, not from today you are academic. I am a duly qualified. If I have no qualification, then, my lord, different thing, my lord. Otherwise, I am the senior most school teacher of the school, my school, my lord. I have a qualification for principal.
Then my submission would be, as the respondent has, private respondent has not yet appeared in
No,
the
he
case.
appeared,
So,
my lord.
My lordship may can direct the director of secondary education lordship to hear both the parties and come to a conclusion and pass an essay order regarding the in-charge lordship.
No, there is no question of that because I am
Because
not doing.
you will have to hear lordship.
No, my lord, he received the notice. After receiving the notice, my lord, he sent a reply to this honorable court directly, and this honorable court rejected and asked him to appear for a counsel. That was not been, my lord, complied with, my lord. And he,
But if he is not before the, if he chooses not to appear before the court, all right.
Yes, my lord. So that's why, my lord, now it is sandbag and hearing both, my lord. That is, my lord, it is admitted position. It is admitted position that I am senior more than, my lord, 10 years senior than him, my lord. That is not denied.
So this academic in charge part is gone.
Gone, my lord. Now only remain is, my lord, the in charge
principal.
And also, my lord, school is also suffering because it is a near about 35 kilometers away from my lord school. 42 kilometers. The school is, my lord, one principal is, my lord, in addition to his normal duties, the in charge principal of a school is very, my lord, difficult for the run the school.
Yes, Mr. Sestri.
Yes, sir.
Have you filed your affidavit?
No,
No, there is no affidavit, my lord.
It is in a motion state now.
No, not motion.
Then I'll file my affidavit lawsuit. A week time may kindly be given. He has already given the academic, so next week lawsuit will consider the final disposal.
My lord, that can be.
Third, Mr. is about the new council assisted by Mr. M. Islam. Third, council for the petitioner and Mr. Sisti to the inspector's department in secondary education department. During the course of hearing, Mr. Sisti has produced a letter, produced an order dated 29/4/2025, passed by the inspector of the school, DDC Dhuri, whereby the present petitioner is appointed as academic in charge of Barkanda People's Academy SS School. SS School. In place of respondent number 4. Respondent number 4. Respondent number 4. But Mr. Monto, learned counsel for the petitioner, submits that not only the order dated 30/1/2024, by which the respondent number 4 was appointed as academic in charge of the Barkanda People's Academy SS School. The petitioner has also challenged the order dated 31/1/2024, passed by the Director of Secondary Education, appointing the Inspector of School PTC Dhuguri, allowing the Inspector of School DTC Dhuguri to act as in-charge principal of Barkanda People's Academy SS School. And that because of the aforementioned order, the petitioner, being the senior most teacher of the school, is deprived of being in-charge principal, and that it will no, and the same order has been causing difficulties in running the school, as the office of the inspector of the school is situated at a distance of
Near about 40 kilometers.
near about 40 kilometers from the place where the school is situated, where the Barkanda People's Academy SS School is situated. And as such, the aforementioned order is also required to be interfered with. But this is Mr. Sisti submits that he may be granted some time to file affidavit in opposition, and thereafter the matter may be listed for final hearing. Here is accordingly allowed, list the matter on next Tuesday.
My lord.
In the meantime, Mr. Sisti shall file his affidavit in opposition. Keep this judgment with.
My lord.
Public.
Item 12.
Item 12, losses, I have inquired to the district. Then treasury officers told the DO that it is not possible for him to lost it because to do without active GPF account, because it is the portal, they don't receive the bill. It does the generate. So he said if the higher authority give him the permission from the online, and accordingly, the director has already requested that there is a department in the finance department, TSD department. So they have generated a mail and also requested the TSD department to look into it, and they are waiting for that loss. This is the instruction that I am getting. He himself cannot give without the active GPF account losses. Because the Free Assam portal, it will not generate.
Now,
bill.
what step has been taken to activate the dormant account?
Dormant account to the finance department, the department has already issued an mail, and also telephoning, they have conversation with going
Mail to the AG.
Finance department. It is a branch called TSG department. It is written there in the lawsuit, in the last paragraph. The TSG branch of the finance department, they are looking after all these things.
Anybody from finance department is available today?
Right now, I don't think lawsuit, all the courts, most of the courts have already.
Okay.
And finance is also not a party, that's why they are not appearing. Anyway, I'll inform them lawsuit.
Yes, what is your instruction?
My instruction is that, my lord, in July 2024, my lord, I approached before the authority, my lord, to activate my account. And my lord, my account is there. July 2000, I have given my bank account number as well as my lord GPF account number, everything I have given. Till today, nothing has been PAN card. Till today, nothing has been done by them, my lord.
But I
Because this point was crop up, my lord, today, my lord. Earlier, they are coming on another point, my lord. They said that we want to make judicial review. That cannot be done, my lord. I have already submitted because this honorable court has directed. Today come. Tomorrow, I think another point will take, my lord.
No, no,
There is nothing.
Mr. Soduri.
Yes.
So without this, without deducting the GPF amount, the
Yes, ma'am.
treasury officer cannot credit the bill in your
Yes, ma'am.
account. That the difficulties are there. Because I know the difficulties. That's because I was also in search for quite some time.
I know.
Mm.
LR, my lord.
So
My humble submission, let them do within a time period, my lord. Otherwise, it is not,
no,
never.
the thing is that it is the business of the finance department.
Yes, my lord.
Can we take the matter tomorrow?
Yes,
Someone-
yes,
ask
yes.
someone to
Yes,
represent
Tomorrow
the
I am not
finance department.
available, my lord. Tomorrow I have some person, Anna Bhavan, Bhagina.
No,
They have
Mr.
He may not be here, Lordship. Only finance council will come and.
Your
after that-
presence is not required tomorrow. Someone can represent you.
Yes, yes.
He will, yeah.
Okay. List the matter tomorrow for further hearing.
Yes. I will inform the council for a finance
In
Lordship
the
present
meantime,
here.
Mr. Siste, learned standing counsel for the, learned counsel for the contempt law, advise the finance department. Advise the standing counsel of the finance department to remain present at the time of hearing.
Yes.
My copy may be tomorrow.
Hearing?
Fine.
At 2 p.m. Yes,
2 p.m.
yes.
Yes, I'll take that.
The letter produced by Mr. Siste shall be part of.
Yes. Oblige.